Maybe.
Yes.
Lordship, in item number 7, Lordship, private respondent have filed an affidavit in opposition.
Hmm.
I am going to file a reply, Lordship. Almost ready, Lordship, but my clients fall sick. Viral infection.
When
2 weeks.
the learned counsel appearing on behalf of the petitioner submits that he is submits that the request for an accommodation for filing of an affidavit in reply to the affidavit in opposition filed by the respondent. List the matter of the 4 weeks.
Wait, the consent of the other side, document item 28, my lord. Item number 28 of today's week, my lord. Of some difficulty, my lord, can it be posted after a week, my lord? In fact, my problem here is, my lord, I have misplaced the brief, my lord, to not trace it out. I've taken the consent of the other side.
The learned counsel appearing on behalf of the respondent railway seeks for an accommodation. List the matter of the 4 weeks.
Item number 12, madam, regarding an issue relating to madam income tax, non-deduction of TDS from the madam bills of a particular madam contractor.
Hmm.
But by now, madam, probably it has been settled, madam. I've already sought for instruction from the authorities. Can it be on Friday, madam? Both the income tax madam is present, madam, standing up. We will have the instruction whether it has been settled or not.
Mr. B. Gogoi, the learned counsel appearing on behalf of the
Here petition, madam.
petitioner submits that he would like to take instructions in the matter as to whether the issue involved in the writ petition still survives. List the matter again on 11th of August.
But similar prayer for item 58,
30?
38 on Friday.
38.
How can it be similar?
No.
Where is
Similar
the
prayer.
income tax?
No, madam, similar prayer, madam, for lifting on Friday. On Friday, madam.
Not Friday. Why Friday?
Any day, madam.
At the request of the learned counsel for the petitioner, matter stands adjourned for 4 weeks.
Madam, there is an interim there.
No interim.
But there is
Why you are not saying anything about this case? What is the interim?
regarding an eviction, madam. So
Eviction?
Yes.
Eviction I'm not going to do.
No, Lordship may take up on Friday or Wednesday. At least today I am handicapped, madam.
Absolutely.
Only on Friday, madam, or Wednesday, madam. Tomorrow or in that case, madam. At least
When the matter reaches, you tell me. Not it. No eviction. No interim order to be extended.
madam, let it be, madam. I have missed the matter today, madam.
We'll take it up in the second half.
No, madam, let it be on Wednesday. At least I will come with a brief, madam.
You don't have the brief.
No,
Okay, you take my brief.
and let it be on Wednesday. At least.
You have obtained a stay as regards an eviction.
Eviction, madam, here he has got there is a patta land, madam. The protection is there only for that portion of the madam, land which he has got the patta. And that is the protection.
Rule 18
And no, it relates to railway.
is Rule 18.
But that
Then, on one hand, your colleagues on the other side always keep on telling Rule 18, you should not do anything.
and
The
when
court
is
should
the-
just not touch it. No, this is a very important matter. It requires to be taken up.
madam, all-
Today
all-
itself.
no, madam, that is
Today itself with it. I am always in support of you. Now let's see how the fight goes. We'll take it.
tomorrow, madam.
No, we'll take it up today and fix it again
Yes,
on
sir.
tomorrow. But
Alright,
this is a very important. Now we will see the fight then. Yeah.
Alright, madam.
My lord, item number 39 has become infractuous.
The learned counsel appearing on behalf of the petitioner submits that the petition has become infractuous and as such would not like to proceed with the same. Taking into account the above, the instant petition stands closed as it has become infractuous.
Item number 225.
Huh?
Item number 225, Lordship.
Ah.
Lordship, may allow me to withdraw the case.
Your name?
Vedic.
The counsel appearing on behalf of the petitioner. Why?
Lordship, actually, the case is for non-payment of the enhancement amount in LA reference case. We have filed an execution case before the executing court. So this petition has been become infractuous because
Infractious.
Yes, Lord.
The learned counsel appearing on behalf of the petitioner submits that the repetitions have become infructuous and as such would not like to press the same. Accordingly, the instant the said repetition stands closed as it has become infructuous.
I appear for the revenue department in these matters, my lord. Item
Give me your
25,
name in that
my
slip.
lord,
Yes, Mr. Borbujari,
my lord.
item number 38.
Hmm.
We'll take it up today. Rule 18.
My lord.
Yes.
With consent of the other side advocate, my lord, I want to mention item number 36. Kindly attention to the.
36.
Right.
Yes, what is it?
My lord, land dispute between two brothers, my lord, regarding partition of a particular plot of land. There due to some lack of document, my lord,
What do you want?
who is trying to file affidavit in the office?
Item number 36. The learned counsel appearing on behalf of the petitioner.
Respondent,
seeks-
sir.
Huh?
My respondent number 5. Private.
Appearing on behalf of the respondent number 5 seeks for an accommodation. List the matter of the 6 weeks.
Only.
Yes, withdraw.
Yes, your lordship.
Okay. Why?
Your lordship, we have received the communication from the respondents where they have agreed to hand over the possession of the land under.
The learned counsel appearing on behalf of the petitioner submits that the grievances of the petitioners have been addressed by the respondent authorities, and as such, nothing survives in the instant petition. Taking into account the above, and in that view of the matter, the learned counsel for the petitioner submits that he may be permitted to withdraw the petition. Taking into account the above, the instant petition stands closed on withdrawal. Yes, madam. You are for whom?
The deputy commissioner, my lord.
You have not paid the compensation to him.
Yes. They are possessors of government land who had prayed for settlement of land under their possession. And that is what the report of the deputy commissioner dated 7/12/2016 reads as.
Yes,
My
what
lord.
is your stand?
There's
You have
no,
filed an affidavit.
no, my lord. I have received instructions.
Yes, what is it?
And they were rejected, my lord. All their applications for settlement, they were rejected, my lord.
It was an application for settlement or what? For payment of compensation.
Yes, well, they asked for compensation in their prayer. They also. Kindly see the prayer, my lord, page 14 of your lordship's brief.
Hmm.
Not to carry out the works of the construction of the new BG railway line over the petitioner's land. Not to evict the petitioners, well, this is very telling, from their lands in possession.
And settle the land with petitioner for adequate payment of compensation for the lands under their possession and so on. Then,
Possession of the petitioners which have been acquired by the government.
so what is your,
But they prayed, my lord, for settlement, they were rejected for in respect of acquisition of land. Their proposals were rejected according to the deputy commissioner's report, my lord. dated 13/7/2016, my lord.
So they were in government lands.
Yes. Possessors, my lord.
Understood? They were in government land.
They were in Khas land, my lord.
Now the land has been acquired. And land has been settled.
It was not, my lord. Their proposals, my lord, they applied.
No, madam. These people were in possession of government lands.
Lordship,
These lands were settled with the railways. And he is claiming that he should be paid some compensation. Yes, what is your case?
My lord, so my case is, my lord, the land was, my lord, newly admitted fact, my government land. But they uses the land, my lord, from their forefathers, my lord, and my lord, paying the Kosi Bohira, my lord. And all are, my lord, land including the tribal based land. My lord, they get the Zirat compensation. My lord, earlier order, my lord, in 191 application, my lord, there was, my lord, directed the honorable court to pay the compensation of Zirat and, my lord,
And,
land. After being verified,
but you are not the owner of the land.
my lord, yes.
Then how do you get the yeah of them?
In the title, people, my lord, they possess the land, my lord, from their forefathers. And in the similar situation, my lord, in Jhalpur district, when the land was acquired for construction of railway line, my lord, the land was settled for a limited period, and my lord, the authority concerned, my lord, pay the compensation. And my lord, moreover, my lord, there is a list, my lord,
Lease?
my lord. That
What
is, my lord,
list?
at page, my lord, 46.
Who has given the lease?
But these, my lord, they applied, the petitioner, my lord, page number,
Page?
page 46. These persons-
List.
Yes, my lord, these persons are also, my lord, they were the, my lord,
So you were given the annual patta?
Yes.
Were you given the annual patta? Then, case you got the Zirat, that you should be happy with it.
this person, my lord, under consideration, this person also,
No,
my
no,
lord,
no.
similar situated person.
I'm not
They
concerned with
applied for
others.
settlement,
I am
my lord.
only concerned with you. You admittedly were in possession of government lands. So you have no right over the land in Kochi. However, there is a Zirat out there. So for that, you are entitled to compensation.
That has,
You have got the Zirat compensation.
yes, my lord, that has given.
But the land as regards the other have already been settled now with the railways. Has been settled with the railway. So you were never there. Now, if you are aggrieved, how can this court now look into it and pass a direction? Look here, these people were there. How do I know that you were there?
Earlier writ petition, my lord, 191 of 2015, my lord. In that writ petition, direction was there.
To
It
consider,
was still under consideration.
to consider.
Yes, ma'am.
To consider is different from a direction to pay.
Yes, my lord.
There was only a consider.
And
So
my lord,
under such circumstances, tell me, what right do you have to get compensation for the land?
only, my lord,
Show me something that you are entitled to the compensation of the land.
they also applied for, my lord, for settlement. And that is, my lord, under consideration. And my lord, in the same.
And why have you not filed any proceedings before the deputy commissioner? For making a reference,
that-
saying that you are a person interested.
That is filed. already
Now what
filed.
has happened there?
Nothing, but it's still pending, my lord.
Yes,
Still pending.
they have filed some application before the deputy commissioner. Why haven't you referred it to the district
So
judge?
that information is not available on record, my lord. That's
Then-
only a statement made by my learned colleague.
Don't ask
You got
this court
the
now
opportunity,
to
my
say that leave be granted to approach the deputy commissioner. No. There is a period within which it has to be done. And these were done under the old act,
Old act, yes,
1894,
1894 act.
or under section 12 of the acquisition. Where do we? Here,
Old act.
there is no acquisition.
Yes. Because the
You were
land is
paid only a
government land.
compensation. There was no acquisition proceedings.
Yes, my.
Tell.
Look, only,
Have you been thrown out or are you still in possession?
no, my lord.
Are you still in
That-
possession or have you been thrown out?
Still not for this. Some portion of the land is under position.
You have not
Hello,
thrown them out?
If ask the
The-
opportunity, my lord.
The railway line has been constructed. And
No, if
their
you have given
proposals
the
were-
land, where's the railways? Have you made the railways a party?
That is the party, my lord.
Where's the railways? No, you have not made the railways a party.
Yes, yes.
Then
My lord, the concerned authorities, my lord, the revenue.
Land has already been transferred to the railway department, by my
Hmm.
instructions,
Then. And if you are in possession,
on payment
do
of
what
premium.
the railways tomorrow will come up with some application out there to throw you out. No case.
My lord, if ask the opportunity, my lord. An observation, my lord.
For what?
My lord, go through due process of law, my lord.
What due process?
Petitioner- That the petitioner will file a petition before the deputy commissioner, a bridge, my lord, that may be considered.
No, you have filed before the deputy commissioner. Deputy commissioner passed some order. You have not challenged those. I can't help you.
Some applications are still pending, my lord, before the deputy.
Very well. Approach,
was-
go before the deputy commissioner. Why should this court do anything? Which application of yours is pending before the deputy commissioner?
My
Show me.
lord, that is a, my lord, only a common application, my lord, that is
Where?
page 24,
Page
24.
24.
Compensation of prayer for compensation of settlement.
And in
Government lands,
pursuance to that, you have already been given the
Zira-
Zirat.
Zirat.
Also for.
And if you are
settlement of the
agreed
land,
out there, you go approach the proper, yeah, but this is not the year to approach. The land is already government land. Where is the question of this?
Acquisition.
And where you are party out here? Did you submit the application, this one? Are the petitioners applicant to these applications?
Yes, man.
Where?
We are number.
That is, my lord,
Uttam Phongsu. Where is the Uttam Phongsu?
more
Not there.
No, my lord.
Upan Rahang, not there. Surendra Kumar Rahong, not there.
No, my lord.
Bhoben Tumung, not there.
No, my lord.
Bhupen Chaudhary, not there. There?
No.
Yes, my lord, there, my lord, page 28, my lord,
Where?
page 28, my lord, serial number, my lord, 61, Uttam Phangsu. Thereafter, my lord, page 29, Surendra Kumar Rahang, Bhoben Tumung, Upen Rahang, all are there. Page 29.
Okay. The instant writ petition has been filed by the petitioners claiming for a direction, seeking a direction upon the respondent authorities not to carry out the works for construction of a new busy railway line over the land belonging to the petitioners and not to evict the petitioners from their lands in possession and or settle the land with the petitioners for adequate payment of compensation for the lands under possession of the petitioners which have been acquired by the government covered by DAG number 713379496 or Patta number K Tauzi Patta 382167 of village Kamalajari, Moja, Sonapur under Sonapur Revenue Circle in the district of Kamrup Metro, Assam. The facts of the instant case is that the petitioners admittedly were in possession of government lands wherein they had built houses and raised crops. Had built houses and raised crops. For the purpose of construction of the BG line, the government of Assam, the said lands wherein the petitioners were in possession were settled with the railways. The petitioners being aggrieved on account of non-payment of the compensation for the lands which they were in possession, as well as on account of the Jirat had approached this court by filing a writ petition being WPC number 173787/2013. This court, by an order dated 3/5/2013, directed the collector Kamrup Metro to verify whether any compensation is payable to the petitioners, and upon verification, if it is found that the petitioners are entitled to any compensation in respect to the Jirat or in respect to the land or both, the same be released to them within a period of 2 months from the date of production of the certified copy of this order passed by this court by any of the petitioners before the collector. It further transpires that thereupon the petitioners herein were paid the Jirat in respect to the crops, standing crops, as well as the houses standing thereon. However, as regards the land in question, there was no compensation so paid, for which the petitioners have approached this court. This court, by then order dated 2/6/2017, no, 9/4/2018 issued notice making it returnable by 3 months. It, however, reveals from the record that there is no affidavit being filed by the respondent authorities. Be that as it may, there are certain instructions on the record the reference of which this court deems it proper to make, taking into account the issue involved. It reveals from the records that the Deputy Commissioner Kamrup Metro had issued a communication on 9/2/2016 to the Additional Chief Secretary to the Government of Assam, Revenue and Disaster Management (LR) Department, wherein the issue involved in the instant proceedings, wherein the grievances of the petitioner were mentioned. Wherein it was mentioned that the various possessors of the government land of village Konai had prayed for payment of land compensation by giving settlement of their possessed land. It was further mentioned that the Zirat oblique the building compensation standing over the government land possessed by the following persons have already been paid. And as such, the additional chief secretary to the government of Assam Revenue and Disaster Management were requested to issue necessary instructions whether settlement of the possessed government land can be given to the persons concerned. It further reveals that pursuant thereto, the Joint Secretary to the Government of Assam Revenue and Disaster Management Department had issued a communication to the Deputy Commissioner Kamrup Metro, wherein it has been mentioned that the land covered by DAG number 218 bracket PT bracket closed, comma 361 bracket PT and 396 bracket PT of village Honai acquired for the construction of the new BG line from Tetelia to Bornihat have already been transferred to the railway on payment of premium, and the Zirat oblique building compensation have already been paid to the possessors of the government land. And therefore, there arose no question of settlement of the land as prayed by the petitioner at this stage. It further reveals that thereupon, the Deputy Commissioner Kamrup Metro had passed two orders on 12/7/2016 and 13/7/2016, wherein referring to the communication dated 19/3/2016 issued by the Joint Secretary to the Government of Assam Revenue and Disaster Management Department, the petition filed by the petitioners seeking settlement of the land were rejected, and the additional Deputy Commissioner's Land Settlement Branch was directed to issue notice of eviction of the structures of like buildings of like Zirat standing over the land DAGs in question. It is relevant to take note of that none of these orders, more particularly the order dated 12/7/2016 and 13/7/2016 have not been challenged before this court. Although the said orders were passed prior to the filing of the writ petitions, upon hearing the learned counsels for the parties, the question therefore arises as to whether the petitioners herein could be entitled to compensation, could be entitled to settlement, as well as thereafter the compensation in respect of their land being possessed by them. Which was settled with the railways by the respondent authorities. Taking into account that the land has already been settled with the railways, the question of granting any settlement to the petitioners did not arise. And as such, the order dated 19/3/2006, communication dated 19/3/2016, wherein the Joint Secretary to the Government of Assam Revenue and Disaster Management Department had informed the Deputy Commissioner Kamrup Metro that a question of settlement of the land as prayed by the petitioner did not arise is in conformity with the provisions of law. Now, the next question, therefore, which arises is as to whether the petitioner being in possession of the land prior to the settlement being given to the railways can be construed to be person interested in terms with, this is done under which act, the earlier Land Acquisition Act 1894.
There was no acquisition, my lord.
Under what provision have you done it?
No acquisition, my lord.
What? No acquisition. You have paid compensation, kindly see
Ziraat,
this.
yes, my lord.
Where? Would
Ziraat
be
to-
person interested in terms with. Now, the next question therefore arises as to whether the petitioners herein who were in possession of the land prior to the handing over of possession prior to the settlement being made in favor of the railways would be persons interested in terms with, this is done under what provision? 64, 1894,
uh,
railways.
railways, my lord.
I think this has been,
দেখা না যায় না।
you have paid some compensation.
অধিগ্রহণ করাটা তো দেখা না যায়।
So although, my lord, here the word used is acquisition, but per se, my lord, it appears that no acquisition proceedings might have been initiated, my lord.
কারণ মাটিতে থাকা
Because it has already been settled to the railways.
Huh?
land.
Since the land in question was settled with the railways, there could not have been any acquisition proceedings. But in the instructions, in the communication, although this word acquisition has been mentioned out there, but it is not acquisition per se.
Then how did you pay the Ziraat?
Might be because of the fact that when they are in occupation, some amount of money has been paid to them.
No, the question is whether they would be entitled to. You see, who are the persons interested?
I'm concerned.
Whether they will come within the ambit of person interested.
Yes, person.
Now, person interested is also a person who is in possession.
Yes, yes,
So they may not be entitled for settlement.
settlement,
They may not be entitled, but the fact that they were in possession
my lord.
would also entitle to them to some form of compensation,
Yes,
isn't it?
yes,
Maybe government land.
yes,
They, just for example, let us assume that A is the owner of the land. B is in possession of the land. B is in possession for which, as he is having a possession out there, some form of compensation has to
Yes.
be apportioned to him.
yes. That is what, my lord, precisely section 5 also gives a handle, my lord, to the person interest 5A. And then, my lord, provisions of section, my lord,
What is 5A?
5A, my lord, hearing of objections, my lord.
Kindly see 2B, 2B or 2J. What is that? Person interested?
Yes, my lord.
Person interested has been defined.
My lord, I'm
Land Acquisition Act 1894.
Three B, my lord.
Huh?
Three B.
2B, 3B.
yes, 3B.
What is it?
The expression person interested includes all persons claiming an interest in compensation to be made on account of the acquisition of land under this act. And a person shall be deemed to be interested in land if he is interested in an easement affecting the land.
When will come in?
Now here, my lord, the fact remains that they were paid, my lord.
Huh?
The persons who were in occupation of the land in compensation, they were paid, my lord. They were paid.
Ziraat.
Ziraat compensation. Admittedly, they will be entitled only to zero because they have made only improvements to the land.
they are not the owners of the land. Only to the extent that so far as some improvements have been made, they will be entitled to that. This communication which is a part of that, I would think so. Precisely saying so, whether that some compensation has been paid to them.
Yes, sir. That's got to. Illegal last line too. Now the next question therefore arises as to whether the petitioners herein being in possession of the land prior to the settlement being made in favor of the railways would be entitled to any form of compensation. There is no a perusal of section 3B of the Land Acquisition Act 1894 clearly mentions, defines the term person interested. Taking into account its importance, the said person in a definition is reproduced hereunder. Now, coming to the facts involved in the instant case, it would be seen that the petitioners being in possession of the government lands accrued, no rights had accrued upon them on the basis of their long possession. Even on the basis of their possession, howsoever long, it is, however, it is further being an admitted fact that the petitioners have already received the compensation in terms as regards the jirat for their crops, for the standing crops and the houses standing thereon. Under such circumstances, there arises no further reason, there arises no further grounds. It is the opinion of this court, under such circumstances, it is the opinion of this court that the petitioners having received the jirat compensation would not be entitled to any other further compensation in respect to the land on the ground that they were in possession of the land. Consequently, this court finds no merit for which the petition stands. Right. Hey, I was curious. Yes, Mr. Dekar, what are you challenging?
But we are challenging an order issuing a warrant of arrest. I mean, just
You have been issued a warrant of arrest. Where?
in a Bhakti proceeding.
Why?
Lord, if I may just quickly place the background, Lord, I'm a director of a company. Lord.
Hmm.
That company had availed financial assistance from a cooperative society. Accordingly, my lord, Bakijay proceedings were initiated. We arrived at a settlement agreement that will pay. Out of 64 lakhs, we made a payment of nearly 24 lakhs. In the meantime, my lord, the company had suffered another setback in as much as the respondent number 6, cooperative, Assam Cooperative Effect Bank, initiated proceedings under the SARFAESI Act. Now they took resort to 13-4 and they handed over the management to a separate company called JNX, who is the respondent number 6. Now, your lordship is aware, after the management is handed over, I cease to be director. Well, notwithstanding that, instead of taking up the Bakijay proceedings against the new assignee, my lord, they were insisting that I make the payment, whereas I was only the erstwhile director. That is the only.
So they have taken over the management. But Bakijay proceeding was initiated thereafter against you.
Bakija proceedings were
Was
initiated
con-
before, but
but was continued against you.
again. No, it's a corporate entity, so therefore all liabilities will also be taken over. In fact,
Show me the order by which they have taken over the partition.
Manoj, will kindly have first, page 30.
Page
30.
Yeah, itong matokti.
30, my lord, fine. This is the first notice.
Hmm.
Now, the second paragraph which your lordship takes up, it is hereby clarified the bank is contemplating to take over management of the business of the above tea company in terms of 13(4)(b) of the Act on the strength of security created against tea crops, tea bushes, plant and machinery of the tea company, which is a substantial part of the business of the borrower. Any agency allotted by the bank shall have to run strictly in terms of all the relevant provisions of law in application, including the above act. It is further clarified that the managing agent shall have to bear all other liabilities of the tea company, including statutory dues, both pending in future. Now, my lord, at the following page, page 31, your lordship finds the agreement.
Wait,
31.
Janek,
An extra 5, yeah, with JNEC. Now, my lord, there's a clause in this agreement which also makes it clear that all liabilities will also be attached to them. That is clause 4 at page 35.
then
My lord, that the period of agency will be for a period of 50 years from the date of execution of this agreement, the length of which period being based upon the
but
outstanding.
where is the order under 13(4) for appointment of a managing agent?
My lord, 13(4), they have issued the notice.
The notice they have issued, but they said we are going to appoint.
Yes. Thereafter, they
proposing.
appointed by way of this agreement.
No, it can't be like this. You see, kindly see the SURFACE Act, some SURFACE Act. SURFACE Act says about a notice to be published in the newspapers to the effect who have
Yes,
been.
but that is at page 40. my lord.
Ah. Yeah, now this is the important.
Yes, now, my lord, last paragraph, your lordship,
Now,
fine.
in compliance with so and so, it is hereby all concerned that so and so are hereby appointed as directors of MS so and so. Effect from immediate away, it is further narrated that all properties and effects of so and so shall be deemed to be in the custody of the appointed directors of the publication. So this is the air by which it has been given effect. Then
Then, my lord, we brought it to the notice of the Bakija officer that since management has been taken over, now you can't hold me personally liable. That is at page 64, my lord. And thereafter, page 114, your lordship finds the orders, my lord.
864. What is this? There's some repetition file earlier.
There was a repetition file earlier which was withdrawn with the liberty.
Okay, dropping of so and so.
But page 113, if your lordship takes up.
Wait. Now, after this 66, what happened 67? 67 is the impugned.
67, my lord, were show cause notices, my lord. And page 113 is the order.
Where's the order?
My lord, these are the order sheets, my lord, I've given a type copy. 113. In fact, on the right column, your lordship will find 24/117, a letter was received from Novokumar Town, which your lordship will see. And finally, there's no response. As such warrant, I responded to this.
So you didn't respond to the notice?
My lord, I responded, my lord.
Where?
My lord, I had given that letter on 24/117.
So notice was issued when?
My lord, thereafter, page 68 onwards, I have been, first of all, the,
No, after 67,
Yes.
this was done on 14/3/2018.
yes, my lord.
Certificate failed to justify by as such proposed notice issued. There is no response from the, did you respond after 14.3?
14, after 14.3, my lord, I preferred an application seeking time. That is at page 68, my lord.
And
Thereafter, I thought I was not furnished with the copy. So I had applied for the copies by page 69.
Mr. Dekar, let us make it simple.
My lord.
Did you after 14.3.2018 in 18 approach and submitted your reply?
I did, I,
The answer is no. then-
but it is otherwise a pure question of law.
What is this pure question?
My lord, can I be held liable as a past director after the management has been taken over? That is the moot question.
For what? Liable for what? This amount
Yes.
was
Was
liable
during
to
my
be
test.
paid prior to the appointment.
True, my lord.
So that amount, the Bakizai proceedings, it was initiated prior to
Yes, yes,
this
yes.
13.4.
Yes.
So your, the initiation of proceedings at that point of time, you were liable.
My lord, I was liable only in the capacity of a director. Now, as per section 15, my lord, I cease to be a director. And the liability is that of the corporation. my lord. Can I be held personally liable? Now that the corporation, in fact, in the settlement, in the agreement also, my lord, it was made clear that the company, DNA, would take up all liability, including past liability. So therefore, my lord, the liability is.
But
attached
why
to-
haven't you replied? If you have replied, the matter would have been over. Why you are not taking up those issues and bringing it here? Simple question. They have asked you, you have not replied. This is
Manoj,
what
I
you have
have-
got,
I
and
have-
then you get a stay out here. You have not paid a single penny.
My lord, I'm not liable to pay firstly, my lord, and second, I had already brought it to the
No,
notice of.
the moment they exercise the power under 13.4,
My lord.
are you saying that the entire liability of yours ceased to exist?
In a way, yes, my lord,
No,
because I
it
was
can't
only
be.
a director.
It can't be.
My lord, had it been a partnership, I would have understood, my lord. But I was only a director of the company. Now, whatever.
What
dues are
company
there-
is this?
Lord.
What company is this?
It's a private limited company.
Private limited company, and who are the owner, shareholders?
Shareholders, my lord, even members and shareholders, my lord, can they be personally held to be liable?
No, shareholders are, who are the shareholders?
Well, the shareholding pattern I have not disclosed, my lord.
No,
but
no,
I
there
am a
has to be the disclosure, but because it made a private limited company sometimes may have a, maybe a quasi partnership.
That perhaps, my lord,
This is what is happening everywhere out here. When the payment of dues come, I am not related.
My lord, but-
Responsibility is the company.
my lord, the agreement, if your lordship takes up for a moment, page 31,
Of
page 31, that's
between
JNX and Assam Cooperative Ethics.
understood. Assam cooperative aspects, but are you saying that the moment you initiate proceedings under 13.4, the liability which was to be paid by so and so ceases?
No, my lord, liability exists, my lord, I agree, my lord.
So if the liability exists, so your liability was there at that point of time. Why haven't you replied to this before the authorities
My lord,
instead of getting a stay here?
my lord, I had already brought it to the notice.
So then what was your problem in, why were you asking for time if you have brought into the notice? Why didn't you, in your reply, no, Mr. Dekar, in your reply, why you did not say, look here, on prior to the issuance of notice, I have issued this may be treated as my reply. Why haven't you said that? Why you were asking for time later? Give me some time for filing my reply.
That he could have done. my lord.
Then,
That he could have done, my lord. So the question here is, my lord, can I be now held liable?
whether you can be held liable or not, that is a question we will decide in a fine day, in a fine morning with the sun rising. Not now.
My lord, and I have.
You now go to the deputy commissioner where?
The Pakija officer.
Pakija office is where?
Yeah, my lord, God.
Huh, there. What is all this thing?
If the liability is there, my lord, the company will pay it. my lord. Now, even if the company was with me, my lord, then also I would have paid it out of the assets of the company only.
Why haven't you taken action against the Assam Cooperative?
I have done that, my lord.
Then what has happened thereafter?
That is pending.
Then you are allowing that to be remain pending. Here, you are not taking action. Here, you got to stay and being happy. Now, whose dues are to be paid? These are all the dues of, what are the dues? Dues for what?
For some, I thought,
Provident fund.
no, not provided.
What?
Well, there was a loan agreement with the cooperative society. They had advanced the loan. In fact, my lord, my plea is, my lord, your lordship has seen that under
So
section,
this is nothing to do with that.
it has got nothing.
Okay, yes, you are there for cooperative bank.
I'm putting corporation department.
Now, what are you doing as regards the payment? You have entered into an agreement with a third party, handed over the management. Then why you are again proceeding with this thing?
Today I have slight handicap, your lordship.
Why?
Because your lordship, I was informed by the senior standing counsel that the instant brief was not handed over, your lordship, in 2018. So I am,
You don't have a brief?
I don't have a brief, your lordship.
Fantastic. Wait,
That's it.
second brief also not? Did you? We'll take it up at 2.
I'm like,
Second brief did you?
Right.
And Mr. Rasko, kindly take instructions out there. What have you done all this while till now? Because on one hand, this is a matter of 2018.
Right.
Now, on one hand, you have proceeded, given it to some other company for the purpose of running the affairs of the management. And then why are you proceeding simultaneously with this thing which has nothing out there? You have already taken steps.
Lordship.
Then what is this double
Lordship,
twice you are taking all
you can
this?
keep
thing?
it tomorrow, your lordship.
No, today, 2 o'clock, 2 o'clock, because 3 o'clock this court will be rising. Yes, next. Yes, madam,
All right.
tell me. What do you want? Quashing the impugn order issued by the electoral registration officer and what has happened?
My lord.
What order electoral registration officer has passed?
It's in
This
case
one?
51, your lordship.
Page 51.
Yeah, lord. And sir, by this order, the petitioner's name has been deleted from the electoral roll. Your
Why?
lordship. Because, your lordship, this is my instruction.
FT.
Yes, lordship, they have not disclosed. As per our instruction, there is a case against them, which the superintendent has conferred to us. And on the basis of that, we have issued notice, they didn't appear, and subsequently their name has been deleted, your lordship. The first notice from the superintendent of police is, your lordship, page number 2, communication to the SDO civil, your lordship.
Now, what is this FT case and some order passed? What
Yes,
is
sir.
this? At page 51.
That is the order, your lordship.
We are concerned with Tulsi Saha.
Yes, yes.
My lord.
You are Tulsi Saha? Okay. Now, what has happened? Any orders passed?
The order that is in page 15, my lords, and notice there are grievances that this order has been passed without any notice has been issued to them, your lordship. But their notice was duly issued, your lordship, but they didn't appear here. So after that, this order has been passed. Your lordship.
Understood. Now tell me, Mr. Ali, what is this reference to be made at page 51?
Yes.
FT case number and court order date. What is this?
That was furnished to us by the superintendent of police, your lordship.
Was there FT case against her?
Yes, it was, your lordship will say. They have, the first proceeding was initiated against their parents, your lordship.
Ah,
Both the parents, your lordship. In that case, during the pendency of the proceeding, the petitioner's father, Bhavata Saha, expired, your lordship. They have said that they were extension of the order for, they were declared foreigners of the spring 1966-71 stream, your lordship.
66, 71.
Yes, your lordship.
Ah,
But they didn't register before the authority, the father of the petitioner, your lordship. Then your lordship will say in page number 6, they have stated that there were 2 extensions. The second extension is 9/6/1998 of the FRO order, your lordship.
Hmm.
That is in page number. Annexure 4, page number 25, your lordship.
page 25.
Yes, lordship.
Okay.
There's a record put up with the petition of the OP, heard both the parties.
It was
Both parties.
decided a foreigner,
Now, in this, as per this order,
but could not
The petitioner
register his
appeared-
name in the scheduled time. So he is allowed time till so and so to get his name registered. So it was given till 1998, 2 months.
but
Then
he has stated himself and he has also annexed the death certificate that for
Bhavato Saha, your lordship, expired the year 1991 itself.
Then,
So if he has expired in 1991, so he couldn't appear in
so
1991.
if their parents were there, you have not initiated any foreigners proceedings against them.
Your lordship, if
Against the petitioner, have you initiated any foreigners tribunal
as
case?
for the superintendent, SP's first communication, lordship, if your lordship come to page 3 of my instruction,
Hmm.
the superintendent furnished in the first row itself, your lordship, the Bhavato Saha expired. Thereafter, your lordship, dependents, Sandan Saha, and number 4 is Tulsi Saha.
This is making it three, but they were, as per the foreigners thing, they were brought under 6697.
But they've never.
The foreigners tribunal had taken a conscious decision to the effect that till a date of June 1998, some time was given to that particular person for getting registration. So the fact that their parents were entitled to, now there is no decision against them.
But that decision is not been furnished to us. That was when notice was issued. But when SP gave us this communication, they've only given us the details, but not the copy of the order, your lordship.
No, if the SP does not do all these things, that is, they all look out.
When in the communication, my
But
instruction,
you have not till now taken any steps against under the against the in the foreigners tribunal against them.
no, from the election, we have deleted their name, your lordship, since they were declared foreigner. As per-
Where they have been declared foreigners?
Because the SP has communicated in his second communication, your lordship. in
Where?
Page 22, page 21, or he has given us a list, your lordship. Where he said
Page 21.
your lordship. Of the
yeah.
instruction. With reference to subject cited above, I have the honor to forward here the list of declared foreigners, along with the cases references and court order, date of so of the declared foreigners for the paper for kind information.
Where is this? Declared foreigners, we are concerned with which one?
And thereafter, in page number 22 is the pre-1971 and post-1971 list, your lordship. And in page 23 is the name of the petitioner, your lordship, serial number 2, your lordship.
Page 23, serial number 2. This is a case of 86.
86.
This 86 is that case.
But the case numbers are different, your lordship.
Then
In this
what is
case,
the age of the petitioner? Yes, what is your age?
Years,
Huh?
my lord, 33 years.
33 years.
No,
What is your age?
Yeah, sorry, my lord.
I'm not asking yours, the petitioners. Yes,
My lord,
you don't know.
53 years.
53 years. As on the date of filing of the writ petition. Isn't it?
10 for 18.
38 years in 10 for 18 years. In the year 2018, the age of the petitioner was 38 years as per the affidavit. So it is 35.
Hmm.
And by around 43 years.
Hmm?
Around 43 years.
My lord, there is
43
an,
years.
my lord, kindly come up to page 37, my lord.
Ah, yeah.
Petitioner's mother has been declared as Indian, my lord. 37, my lord. Relevant portion, my lord, to page 38, my lord.
Huh?
Page 38, my lord.
Where?
Annex 10, my lord.
Order is good.
Page 38, your lordship, the relevant part in right below the order, your lordship.
Order, my lord.
Not have. Good. So this person, Sifali Paul, Sifali Saha, is your mother?
Petitioner, my lord.
His name has not been deleted.
Huh?
Her name has not been deleted. Pandavati.
Understood, but what are you doing? The mother has not been deleted, you are deleting the daughter.
No, son.
After this, did she go to Bangladesh or there? Then what is all
So
this?
we have
thing?
already communicated, asking the superintendent.
You are
to provide
doing
us a
on the
separate order.
basis of some case. You have you brought the order out here of
No,
that
the order
case?
has not been with us. We have been communicating, but
Please set aside all these things.
if
You take your decision if you find that she is a foreigner. You can't remove this thing. That is what. The instant petition has been filed by the petitioner being aggrieved. by the order dated 27/2/2016, issued by the Electoral Registration Officer 29 Kokrajhar West (ST LAC) and Election Officer Gosaigaon, whereby the petitioner's name at serial number 2 was struck off from the electoral roll 2016. Full stop. From a perusal of the materials on record, it transpires that there was a proceedings initiated under the, what is this proceeding under what provision? Under the Foreigners Act? Foreigners Act or Foreigners Order? What is this? Foreigners Order? Under the
And she was allowed to register under.
Foreigners Act 1964. Foreigners Act 1964 against the father of the petitioner in FT case number 227/K/86. Full stop. By an order dated 9/8/1998, the Foreigners Tribunal Dhubri, Gwalpara and Kokrajhar had opined that the father of the petitioner was a foreigner of 1966-73 stream on 27/10/1986, but could not register his name on the scheduled time. So the petitioner's father was allowed time till 9/6/1998 to get his name registered by FRRO. Full stop. It, however, is relevant, however, to take note of that the petitioner's father expired on 2/2/1991, as could be seen from the Annexure 5 to the said writ petition. It further appears that in another proceedings, being case number 342/K/86, declaring the mother of the petitioner of 1966-71 stream by an order dated 3/6/1994. Secretary to the Government of Assam Election Department, joint so and so, which is self-explanatory. And as the matter pertaining to the district elections officer is dealt with by your office. So you are thereby requested to kindly submit the information directly to Devashish Bua, Standing Council of so and so with an information to him. This is not relevant. Yeah. As no affidavit has been filed in the meantime. Mr. A.I. Ali, the learned Standing Counsel for the Election Commission of India, had submitted a bunch of documents to justify the action taken by the electoral registration officer to strike out the name of the petitioner. From the documents so available, it transpired that the election registration officer had issued the impugned order insofar as against the petitioner on the basis of a communication issued by the Superintendent of Police B, Kokrajhar, dated 29/12/2015 to the District Election Officer Gosaigaon. In the same communication, there is a reference made to the petitioner. To the said communication, there is a list wherein the petitioner's name is seen at serial number 2 in respect of list of full particulars of declared foreigners of pre-1971 and post-1971 who were declared by the Tribunal Kokrajhar. And there is a further reference to made to the orders so passed in FT case numbers as well as the court's order date. This court inquired with the learned counsel for the ECI as regards the order so passed. However, nothing could be produced before this court to get effect. Taking into account that there has been no affidavit filed and the only materials on record so produced do not show and from the materials on record so produced by Mr. A.I. Ali, the learned Standing Counsel for the Election Commission of India, do not show any orders so passed by the FT against the petitioner. This court is of the opinion that the order dated 27/2/2016, insofar as the petitioner is concerned, requires to be interfered with, taking into account that the same has been done without any basis. Accordingly, the impugned order dated 27/2/2016, insofar as the petitioner is concerned, is interfered with. It is, however, next. This court, however, makes it clear that if the officials, that is the electoral registration officer, is able to trace out any orders of the foreigners tribunal against the petitioner, declaring the petitioner as a foreigner, the electoral registration officer would be at liberty to take appropriate steps by providing the petitioner a reasonable opportunity of hearing. The records so So the documents so placed on record, placed by by the standing council of the ECI is kept on record and marked with the letter X.
Please the Lord.
Hmm.
My lord will be the last order, my lord. They need to have taken instruction as.
Last order said non-appears for the respondent number 6 and 7. Though their names were included.
On my lord, 4-5, my lord.
Yes, what is your matter?
Matter, my lord. The police atrocities have been done upon the petitioner, my lord. He,
Police atrocity.
not only police atrocity, my lord, the inaction of the police, my lord.
What
There was there, my lord, lordship kindly.
what did the police do?
Police, my lord, they have entered in the after sunset, my lord, when the petitioner was a lady, along with her infant baby, my lord, that is there in the report, my lord, entered into the meeting. 1 o'clock in the night to the house of the petitioner, woman.
If I may most humbly draw your lordship's attention
Huh?
to the counter affidavit, my lord. Fine.
Yes, did you enter?
Yes, my lord.
After
They did, my lord.
after that,
But he was an accused in a case. He had
who?
petitioner number 3, the husband of the petitioner number 1. He was an accused in a case. He vandalized the home of a private respondent before this honorable court, respondent number 7 or 8.
Hmm.
Respondent number 8. And
Petitioner is
respondent-
one. Manju Bibi.
Yes, my lord. Petitioner number 1 is the wife of the
No,
petitioner number.
no. We have only
3.
one case. How many cases are?
Okay.
We are concerned with 2569 of 2018. There's only one petitioner.
Only one.
Manju Bibi, yes, my lord. In the other matter, in the Abdullah Ali, we filed a counter affidavit. my lord.
Hmm.
The other matter.
On the last occasion, my lord, they need to have filed. my lord.
Yeah, this is another matter. Abdullah Ali,
Yes, my lord.
Mohima Bibi.
It is
and so and so.
connected, my lord.
No, this is Manju Bibi, Anwar Hussein's wife.
Anwar Hussain. My lord, Anwar Hussain is an accused.
Understood, but what are you doing out there disturbing the woman?
He was there in the home, my lord. He was arrested from that.
Should I refer this to the division bench? What has happened? Have you seen that?
My lord.
The
There
same
was a
state of,
lady, my lord. There's a lady.
it is absolutely the same case.
Yes.
When habeas corpus was filed, where the entire police station was directed to be suspended, you want the same fate? Same fate. You just see the YouTube out there.
I have taken.
Only you see only that case only when it refers to the division bench. The SP was suspended, the entire area was suspended. You want the same thing. And there is no affidavit out here. It's a serious matter.
That, my lord, that has returned in.
How
FR.
on earth, as she is not accused, let us remove this. We are not concerned. As she is not the accused, Manju Bibi, how can you enter at night?
Her husband was
and her
wanted, my
Backbone
lord.
also, my lord. He
In
had
a
to
criminal
go
case.
Apollo, my lord.
Her husband was wanted in a
So
criminal
what?
case.
So what? How can he this you and you arrested you?
No,
Then what did they do?
Husband was arrested.
no, not arrested.
What happened to you?
My lord, no.
Nothing. Then why are you filing the requisition?
My lord, they have caused, my lord, atrocities in the night, my lord, entered and dashed me. And I, as a result, my lord, I had to go to Apollo for checkup. As on date, my lord, I'm facing same fate.
You are?
I'm facing, my lord, problem, my lord, because I was dashed like anything, my lord, by the police authority in my house.
There is some commission, some police atrocities
I have
commission.
lost the complaint there.
Then what happened?
There, my lord, that I do not have the communication.
Huh?
That communication, I do not have instruction.
Why?
What happened to that man?
You are not interested.
I'm interested. my
Then
lord.
why have
The
you not
police
taken that instruction? We'll take it up on some other day. And madam, you file your affidavit on this.
My lord, one thing,
You
my lord, police-
can't get away by not filing affidavit in this matter. The SP, we have a SP out here? Yes.
Yes,
Who is the SP? Let the SP file an affidavit.
Yes, my lord, in the second matter, Kamrup Rural.
Let him file an.
Lordship, kindly have a look the page.
I'm not going to. You are not interested.
Well, I'm interested.
No, if you are interested, why haven't you taken note of that? You're not interested. You seem to be, I'm not bothered.
No, my lord, not.
Then if you are bothered out there,
I
why
have
not?
received the instruction, but I have miscommunicated, my lord.
You have
What happened, my lord?
miscommunicated.
What happened, my
Fantastic.
lord, I do not remember.
Anyways, no problem. Yeah. The respondent number 5, that is the superintendent of police, Kamrup. And again,
Kamrup
eight
Rural.
case, main case. Alleging atrocities being committed upon a woman by whom?
By the police officials, OC
By?
6 and 7, my lord.
By the police officers in respect of Hazu police station.
My lord,
And we have not made the officer in charge Hazu police station a party
I made party.
or by name.
Yes,
Yeah.
6 and 7.
Alleging police atrocity by the respondent number 6 and 7 upon a woman, that too after dusk. The instant repetition has been filed for initiating inquiry proceedings against the respondent number 6 and 7. As well as for a direction upon the respondent authorities to act upon the complaints made by the petitioner via the annexure 5B, 5C, 5D, 5E, and 5F. It appears that this court had issued notice on 8/6/2018. And till date, no affidavit has been filed. This is a very serious matter. And as such, this court directs the respondent number 5,
6 and
to
7.
Mr.
Five, five,
Borboya,
yes. Sorry, my lord.
directs the respondent number 5, the superintendent of police, Kamrup Rural, to file an affidavit in the matter as regards the allegations so made. This court further takes notice that an officer in charge of the police station, officer in charge as well as the sub-inspector of Hazu police station, then have been impleaded as the respondent number 6 and 7. However, they have not filed their affidavit. This court fixes this matter again on 11th of September 2023. It is made clear. No, 11, full stop. The affidavits be filed by 7th of September 2023 without fail. It is made clear that if the affidavit is not filed, the superintendent of police, Kamrup Rural, shall be personally present in the court. Please start with you. Please speak.
Well, ID of supply of fertilizer was suspended at a respondent number 3 without putting any notice of the matter.
What ID?
Wholesale ID.
What is this?
Well, we are suppliers of fertilizers. We are wholesale people.
Hmm.
Now, for the purpose of purchasing the fertilizer, we have to obtain an ID. Now, your lordship, my prime supplier was the respondent number 4. Now, the respondent number 3, he issued an email stating that to stop my supply of fertilizer. Your lordship, page 19.
Page
19, your. That is the email by the respondent number 4. I
Who
would
is
like
respondent
to
number
inform-
4?
I am happy.
Brahmaputra. And this has been done by whom?
Your lordship, by respondent number 3, they have issued instructions to the respondent number 4, saying that my ID should be suspended, your lordship. In their affidavit.
Who
by
has
the
issued?
lordship,
Who has issued?
The respondent number 3, joint direct.
Joint director has issued to the respondent number 4.
Lord.
And
So we have
accordingly,
only-
they have
we have-
done it.
Lord,
No notice.
no notice, no so forth, and
Where is your ID?
your lordship, here. Page number 14, your lordship. This is my license.
But Mr. Counsel, this is only for 3 years.
Lordship, regularly we update. Thereafter,
You have not updated.
no, we are,
No, this is an acknowledgement.
we are renewing it. So it is renewed.
So where is your ID?
Lordship, ID separately here is not mentioned, but your lordship may kindly pick up the affidavit by respondent number 4 at page number 6.
Madam, you are paying for?
That's it, 1 to 3.
Why have you done this?
That's it, I need some, updated instruction, Lordship.
For what?
That's it, actually, this, matter is handled by, D. Sotri. Today, he has some, difficulty, Lordship.
Whatever may be. You have issued an email to him
Lordship.
and he, without giving him an opportunity, have cancelled it. He says that he is bound to listen to what you say. And what is this ID business? What ID do you provide?
For supply locate, they are getting some items locate from restaurant 4. And for that, they have obtained for ID locate, and accordingly, on the basis of the said
ID is given under what provision? You are the person who is issuing ID. You must be knowing under what provision you are issuing the ID.
only they have, locate, we have in our affidavit, we have stated that the restaurant 3 has asked us to please deactivate the wholesale ID,
Understood. I've seen that.
but
I'm only asking you under what provision? What is this provision of issuing ID?
I think it is issued by the restaurant 3 because ID locate in our affidavit.
If it
ID
is
number
the
three,
respondent number 3 who is issuing the ID, then why, how can you cancel it?
ID Agri Development Center. It is ID number.
How
2.
can you cancel it then? If it is issued by respondent number 3, the respondent number 3 will take.
Since they got instructions from the respondent number 3 to suspend my ID. That is why they,
Your ID has been suspended.
Lord,
Is there a stay?
yes, Lord.
Now you are working.
Lord,
Now what, your ID has been extended.
extended.
Where?
Lordship,
When it has been extended?
Lordship, 9/8/2019 was the interim order passed by this authority. Thereafter, within 2 days, we have, our activity, ID has been restored.
Restore.
Restaurant.
Madam, if you want to take any action, or both of you want to take any action, do it by following a due process. You don't do it at their behest. As now it has been already extended, because the earlier was for 3 years, which ended in the year 2021. Now it has been further extended. You want to take an action, issue him notice and do it.
Sure.
Suppose it of- The petitioner herein has approached this court being aggrieved by the suspension of his wholesale ID which was issued to him after the petitioner was issued license under the provisions of the Fertilizer Bracket Control Order 1985. The basic case of the petitioner herein is that the said suspension of the ID by which the entire business of the petitioner had come to a standstill was without following a due process and also in violation to the principles of natural justice. It appears from the records that this court, by an order dated 9/8/2019, issued notice and further directed the respondent number 2, 3, and 4 to restore the wholesale ID of the petitioner within 2 days from the date of receipt of the certified copy of the order. Further to that, leave was also granted to the respondent authority to take further action in the matter in accordance with law after serving proper show cause notice upon the petitioner. The learned counsel appearing on behalf of the petitioner submits that pursuant to the order dated 9/8/2019, the wholesale ID of the petitioner was restored and the petitioner presently is carrying on his business. He further submits that there has been no further steps taken by the respondent authorities thereafter. This court further finds it relevant to take note of the affidavit in opposition filed by the respondent number 4, and more particularly to paragraph number 4 and 5, wherein it has been mentioned that the suspension of the wholesale ID of the petitioner was on the basis of an email received from the respondent number 3. And the respondent number 4 took up that action, taking into account that the respondent number 4 was bound by the orders passed by the respondent number 3. Taking into account that without a wholesale ID, the petitioner would not be in a position to carry out his business. And as such, suspension of an ID would entail civil consequences. Under such circumstances, the respondent authorities, more particularly the respondent number 3 and 4, ought to have taken the steps by providing the petitioner an opportunity of hearing. In that view of the matter, as admittedly no steps in that regard was taken, and the respondent number 4 had also admitted in the affidavit that it was just on the basis of an email received from the respondent number 3 that the wholesale ID of the petitioner was suspended, this court is of the opinion that this court sets aside the action on the part of the respondent authority number 4 to suspend the wholesale ID of the petitioner. Accordingly, the instant writ petition therefore stands allowed. Before parting with the record, this court finds it relevant to observe that if the respondent authority has reasons to suspend or cancel the wholesale ID of the petitioner, the respondent authorities can do so only by providing a reasonable opportunity of hearing to the petition.
Hello.
B-revaluation criteria of a tender has been challenged.
Huh?
B-revaluation criteria. And tender well settled long back, 5 works were there, 3 completed, 2 are under extension. My lord.
Then
It become infected virtually, my lord.
impacted,
Just settled only.
you were paying for oil and natural
Yes,
gas.
my lord. Yes.
What have you done to the tender now?
Tender, my lord, only settled. And work, 3 works completed, 5 works were there.
Transfer the period, respondent to file affidavit heard on the prayer the sale will on returnable date.
My lord, I
Now,
will,
there's no stay,
no,
so nothing remains.
nothing remains, sir.
And what was the period of the contract?
My lord, period of contract, my lord, 2 under extension, 3 completed.
Huh?
5 works were there, 3 completed. In one respect, my lord, the retender was issued. These are the, my lord, copies I have.
Notice inviting tender. Area one,
Area
Area
one
one,
complete, my
two,
lord,
three,
area one
four, five.
complete.
huh?
Area two, my lord, retender was issued. So it is under extension now. Area 3, my lord, it is under extension, 4 and 5 complete. This is the instruction, my lord.
So there was a retender.
In one case only.
No, you said two.
Retender in area number 2.
And what about three?
3, my lord, already earlier issued. Earlier issued. Then, my lord, settled, already settled. These 4 were settled at the initial stage. So, but 2 is concerned, my lord, that retender has to be issued.
The instant writ petition was filed challenging
Page 18, my lord.
clause 2.1A
Yes.
in the bid evaluation criteria or of the in the bid evaluation criteria pertaining to tender number L26 BC 19018.
Yes.
Puts Mr. G.N. Sahewala, the learned senior counsel, submits that the challenge was made in the year
From 19.
2019 by way of the instant writ petition. In the meantime, out of the 5 areas for which the tender was issued, in respect of area number 1, 4, and 5, the
Yes.
work has already been completed. And as regards the area number 2 and 3, the work would be completed in a short time. So taking into account the above, this court finds no reasons to interfere with the challenge made in the instant writ petition for which the instant writ petition is dismissed. You can bear it. Now, in that, it is this court further taking into account, had also taken note of the certain documents which have been submitted by Mr. G.N. Sahewala, the learned senior counsel, which is kept on record and collectively marked with the letter X.
Much.
But,
Hmm.
by this application, I have challenged the full order dated 16/9/2020 passed by the Register of Property Societies Assam, my lord. And as well as the impun requisition dated 20.
You are challenging the order dated 16/9/2020.
Yes.
Why?
But by which the petitioner was removed from the post of chairman of the property. But what has happened, the,
Page.
my lord, page 72.
Who has passed this order?
This order has been passed by the additional register of property society. Assam.
Then what happened?
my lord, what had happened, my lord, initially, the last AGM and election of the Kalapani Cooperative Society was held on 23/6/2019.
Hmm.
And in this election, the petitioner along with other 14 persons were elected as the board of directors. And thereafter, in the first meeting held on 10/7/2019, in that meeting, well, the petitioner was selected as the chairman of the board of directors of the Kalapani Cooperative Society. And thereafter, on 18/8/2019, the meeting was held, executive board meeting. In the board meeting was decided to construct a godown of the society. And accordingly, that has been constructed and the voucher has been placed and thereafter approved by the board. But suddenly, at the instance of some of the board of directors, well, on 26/12/2019, which is that page 54, a requisition letter has been submitted before the ARCS at Chingwali. And pursuant to that requisition letter, my lord, which actually supposed to have been filed as per the act, my lord, before the petitioner, that has been submitted before the ARCS. And then ARCS has given an inquiry on the basis of the
Was there any resolution on the 36-4?
my lord,
Was there any resolution by in terms of 36-4?
no, my lord, there is no such resolution, my lord. All along, they have stated that the no confidence motion has been brought against the petitioner. That is the 43(2). Section 43(2). The requisition can be seen, my lord, page 54.
What is the president or the chairman in the event of being physically incapable? The vice president, whenever he can take control, like the president can be presented before within 2 days. If the chairman of the it fails to hold the meeting. No, I'm saying about Section 36, that there shall be a president and vice president in a cooperative society to be elected by the board from amongst its directors in accordance with the provision.
Yes.
Vacancy in the influence of the vice president may resign his office at any time after notice in writing to the president, and the president may resign by giving it to her. The board may, by resolution passed by a 3/4 majority
Yes.
of the director
Yes.
present and voting at a present meeting held for the purpose, remove the president or the vice president. Such meeting shall be presided over by the president or the vice president against whom. Now, this is under, and if you are aggrieved, then you can go under 36(5).
Yes.
Now, as per section 43,
Yes. 43(2).
it stipulates a period of notice similar to the Panchayat Act.
Yes, yes.
Then it says that if the president or the vice president, as the case may be, fails to hold the meeting of the board under subsection 1 or the special meeting of the board under year within the period specified therein, he shall cease to be the president of so and so, as the case may be, on the date of expiry of the specified period. In which case the remaining board members shall elect. So 43(3).
Yes.
So when did you get the notice?
Well, the notice has never served to me.
Oh.
That is my basic allegation.
Then what? How does the
That's why, my lord, the requisition can be page 54 addressed to the ARCS.
address to
54, madam.
Ah.
This is the so-called requisition notice
then?
to the Assistant Registrar of Cooperative Society.
Hmm.
Then, my lord, the Assistant Registrar directed for hold an inquiry into the matter.
Hmm.
A inquiry was also conducted.
Hmm.
On inquiry was conducted on 3/1/2020, my lord.
Hmm.
And then in that inquiry, my lord, the petitioner also present
Hmm.
and discussed regarding the some allegation brought against the petitioner. The inquiry report has not been
What
submitted.
is this page 59?
My lord, page 59. Page 59 in the resolution.
Pursuant to that,
That request. And what
then
has
who-
happened, my lord, they have stated,
who called for the means
well,
this-
as per the direction of the ARCS. But that letter has also not been furnished to the petition, not communicated. Because as per the section is very clear, 43(2), that the requisition should be submitted before the chairman. If chairman will not hold the meeting within a period of 15 days, then automatically he ceases to be a chairman. But that requisition never start upon the petition. And all along, my lord, in the resolution, they stated regarding the no confidence vote.
Now, this no confidence motion was held on 21/2020.
Yes,
This is in pursuance to this page 54.
yes.
Page 54 is dated
Page 54 is dated, my lord, 26,
12,
yes,
12/2019.
19,
And this document was not given to you.
yes, not. It was addressed to the air.
So are you challenging this
Yes.
meeting?
Yes.
When?
Thereafter, my lord, after the resolution, I have filed an appeal under section 111.
Okay,
Before the
then,
register. And on the basis of the appeal, my lord, this 16/9/2020 order has been passed.
now how did the additional register
Additional register, my lord,
exercise that power?
I think, my lord, that the power has been conveyed by the register to the additional register.
Is it?
But there is no such communication like that, my lord, directly passed by the additional register.
Your appeal is under 36(5).
No, my lord, appeal 111 as well as 36(5) because of the fact that when the impugned resolution has been approved by the ARCS, my lord, he said that
Understood, but where is the question of you are appearing corporation department?
Lordship, no, I'm hearing the.
Where's the corporation department?
no affidavit has yet been filed, my lord. Till
No corporation department.
Mr. Talukdar, I think, my lord, appeared.
Where is he? Now you are the president,
Yes, Lordship,
chairman.
yes. Lordship, actually, counsel for respondent number 7, leading counsel, Mr. Pia is out of session for some urgent.
Leading counsel, Mr.
Yeah, AR Pia is out of session. Mr. AR Pia
A.R.
is the
Bhuya.
leading counsel for respondent number.
I'm not concerned with it. You have not filed your affidavit.
Lordship,
Not yet.
actually, as per order 22(5), we have been asked to produce original records related to requisition and
I'm asking you, you are not interested in filing your affidavit.
Lordship will be filing.
When?
May allow a short date, will be filing.
Mr. R. Islam, learned counsel, has prayed for listing of the case after ensuring it is submitted that he has the consent from the you sought for time.
Yes, my lord, earlier occasion, my lord, some.
UK so and so as sought for as Mr. P were appearing on behalf of referring sought for time. Are you not aware that this matter requires an early disposal?
No, my lord, the term will be completed. Term will be completed on, my lord, 23/6/2024. The election was held on 23/6/2019, 5 years. So ultimately, after completion of the term, my lord, the petition will be in fact.
So should we fix it after 2024?
No, my lord.
Why we sought for adjournment?
No, earlier occasion, my lord, I have some personal difficulties. That's why, my lord, I thought for that.
When are you filing your affidavit? Who is appearing for corporation department? When are you filing your affidavit?
A short date will be filing it.
Next week?
Probably.
This is the matter taking into account that the term of the cooperative society.
Yes.
The board of the cooperative society would be ending on
On my lord, 23/6/2014,
20. List the matter again on 13th of September 2023. The respondents, both the corporation department as well as the private respondent, are directed to file their affidavit without fail, are directed to file their affidavit by 31st of August 2023. So the petitioner in the meantime would be at liberty to file their reply by 11th of September. Please check. It is made, this court, however, finds it relevant to observe that none has appeared on behalf of the corporation department when the matter has been called.
Probably.
My lord, your lordship may take this contempt matter.
What?
Contempt matter.
What is this matter about?
This is matter about, my lord, I have challenged the termination of the contract by the respondent.
Termination of your contract.
Yes.
These are 3 repetitions.
Yes, sir. Thereafter, some other letters were issued by them
Your
Order,
contract
sir.
has been terminated for why?
for delay in execution of the work.
What is wrong?
Wrong is that they, without granting any extension, they directly terminated the contract when the termination was not aligned. When the
Is it
contract
a
was not
mandate
aligned-
that they have to grant you the extension?
Yes, there, unless and until extension is granted, my lord, this termination is illegal in the eye of law. Because Hind concession clearly says, my lord,
Would
if
they?
time is not essence of the contract, and if the contract expired, then the respondent must grant extension, putting the petitioner on notice that if you fail to complete the work by that time, then they can terminate. Then it is valid. As per section 55.
Let us see the contract then.
My lord, first of all, I am coming to this contempt matter.
On time we will look later on. You want to put somebody behind a bar. First you come to your main thing,
lord,
whether
they-
you have a case or not.
My lord, they are with.
Then we will see about the contract.
My lord, they are withholding 52 lakh rupees, more than 56 lakh rupees of other contract. That
Of?
is of other contract, my lord. Security deposits of other contract, independent contract, which as I have completed the release also, my lord. But because of some technical difficulty of the bank, my lord, merger of the bank, it was returned back to them and now they are not paying.
Now, why are all these matters taken together?
Because the honorable court has checked together, my lord.
Understood? You must have stated, otherwise why will the matters be
Yeah,
taken
yes.
together?
Segregation is necessary.
And are you challenging your contract or not? The termination.
Yes, I am challenging.
And then when they terminated, they must have invoked the security or have taken that particular amount.
Yes.
And you have challenged that.
Yes.
There was a stay.
There was a, no, my lord. Actually, what happened, my lord, your lordship may kindly see this order, my lord, of this honorable court. Then the matter will be collected.
Dated,
In contempt, my lord, the order is there, my
which merit petition?
read petition, my lord, this. Read petition 3900,
Dated,
dated, my lord, 6/10/2020.
shall obtain it. Issue notice. Heard on the employee issue notice. The loan shall apply this matter by freezing its e-portal account. The petitioner has been prevented from withdrawing its dues relating to other contract, and if so, the remedy thereof. If need. Yes, what is the
Now, next order, my lord, your lordship may kindly see the order dated 2010-2020, my lord.
then?
This is the undertaking given by them, my lord.
Yes, receiving
By freezing
instructions
of
from
the
the
e-portal
respondent to the,
account
by
of the
freezing
contractor.
the account, the contractor will not be able to. Action does not prevent the contractor in any way to withdraw their payments from the IOC. They are free to carry out their ongoing work and to receive payment for those. Then,
Then, my lord, what happened? Your lordship may the security deposit of 56,89,537 of another content, my lord, which was released by them. After that, my lord. But due to the technical difficulties of the bank, my lord, it was returned back to them, and then now they are not paying. They are saying that your e-portal is freezed because of the recovery of risk and cost amount relating to the instant contact.
now, as per the contract
Yes.
entered into
Yes.
between you and him, if there is a delay, I don't know, I have not seen it. If there is a delay, can they impose liquidated damages?
If the delay is caused by the contractor, my lord.
Understood.
Yes.
Can they impose
Yes,
liquidated
yes,
damages?
yes, my.
Now, how will they get the liquidated damages as per the contract?
My lord, they have already forfeited my security money, my performance guarantee, my bill is also with them.
Okay.
I am not asking for release at this stage, my.
No, very well. So, the total amount they have imposed as liquidated damages upon you is how much?
My lord, liquidated damage after termination of the contract cannot be imposed.
We'll look into that. But how much they have done so?
They have not done so much.
They have not imposed liquidated
No.
damages.
No,
Now, on what basis are they forfeiting your security deposit and all?
there is a risk and cost amount. After termination of the contract, the tentative amount for execution of the balance work will be 3 crore something. Tentative amount they are on that basis they are, my lord, withholding this amount. And this is what this amount is.
So they have terminated at your risk and cost,
Yes,
and thereafter they are trying to recover that amount
yes,
from you,
from me.
and from there, that amount which has been kept it does not suffice,
Not yes,
and as such they are withholding your amounts in respect to other contracts.
yes. And despite this undertaking given by them, this is also if the undertaking is given by them, my lord, they cannot withhold my another amount, my lord, which is the security money of the another contract, which I have successfully completed. They paid the final bill also, my lord. This is a mere claim, my lord. This is not a claim adjudicated by the court of law. A mere claim cannot be a ground for recovery of the amount from the other contract. And that apart, when the undertaking is given, my lord.
What is the undertaking?
By freezing of the e-port account of the
The
contract.
first paragraph is in respect to blacklisting.
Yes, I am not on that.
You are on the second paragraph.
Yes.
Now come to the second.
By freezing of the e-port account of the contractor, Mr. So-and-so, Mr. So-and-so, the contractor has been restricted only from participating in the tender of IOCL. Thus, the period of 3 years from the date of holiday listing. I am not on that, my lord.
You are on the second part.
Second part, my lord.
The above action does not prevent the contractor in any way to withdraw their payments from IOCL,
Yes,
and they are free to carry out their ongoing works and to receive payment
Payment
for those
for
works.
those work. But they are withholding that amount on the basis of this, my lord.
Have they mentioned it out there in the affidavit that they are doing it in view of this?
Yes, in their affidavit in the contempt they have filed.
Yes, Mr. Chaudhary. So you have challenged the blacklisting.
Blacklisting also, initially, my lord, they terminated. I have first writ petition, I have filed.
You have challenged the show cause notice.
Yes.
You have challenged the order dated 34/2020 as well as 31/8/2020. Let us see those orders. What is this show cause? And it's 177. Show cause portfolio. So this blacklisting is done prior by giving you a notice.
Yes, yes.
Then comes to set aside and quash the order dated 34, page 190. The total risk and cost amount comes to 10,89,385.
No, my lord. Recently, they are saying that 3 crore,
Where?
3.2 crore, my.
The page 191.
Cost of construction of footing. Yes, 10 lakh. In this case, my lord, they are saying 10 lakh.
Then
Now they are saying 3.2.
then blacklisting is at page 195.
Yes, my.
So this period is going to end very soon.
Very soon, my lord.
Then what else? 31/8/2020. Which is that?
31, my lord.
Ah,
About risk and
31/8.
cost, my
Yeah.
lord.
Intimation for no, this is blacklisting.
Yes, this is blacklisting.
So you are challenging this holiday listing. And what is this? Another one you are challenging,
Another
number
recent
4,
one, my lord. Here,
Annexure 16. 16 is what? Department of Use. This is for your information that your account under so and so in the future has been part with the contract. So what remains in this writ petition? Any further?
writ petition,
Show cause notice was there. Blacklisting is coming to an end. Then comes your debarment. They are saying that you will be allowed to use for other purposes.
they are not allowing, my lord.
That's another aspect.
Yes.
We'll look into that.
Yes.
But they are, as per their stand, they will be allowing you to use this particular account for the purpose of getting for other bills and all.
Yes.
You'll be entitled. So what remains in the writ petition? You have not challenged out here the termination.
Permission, I have challenged, my lord.
Where? Where you have challenged that? Page 191 is different. 191 is only 10 lakhs.
In first writ petition, my lord, 279 of 2009.
Hey, Aluki, 2790.
Page number 19, man.
Page
Page number 19, man. 19. Prayer number 3, man. To set aside and quash the order of termination of the work order number 22, dated so and so. Termination issued by the responsible body.
Okay. Now let's see this So this is your main,
Yes.
main,
Yes, when it,
if you are not successful here,
yes,
others go.
Yes.
Okay, now,
prima facie, my lord, the termination is no.
why?
Why? Because there was no contract at that time when it was terminated in the eye of law. When the contract expired, my lord, then thereafter without granting, if without granting any extension, the termination is done by them, that is still illegal matter. Unlawful.
So you say that the period of contract had flux.
Yes, by a flux of time expired. Now, as per the law, the mode is provided. They have not applied that mode. Directly they have terminated.
So
that
you say that there cannot be a termination after the
expiry of the
after the contract has already terminated by a flux of
by a flux of time, by the act of the party.
When did the terminate the period of the contract? Let's see the work order.
Work order at page 224, my lord.
Before.
It was for the 9 months.
And period of the contract?
9 months, my lord.
9. Clause?
At page 25, my lord, work order is there.
Where is it?
In third paragraph, period is mentioned. The entire work shall be completed in a duration of 9 months from the date of handing over the site, which will be taken from the 10th day of the date of placement of the commencement order or the actual date of handing over the site, whichever is earlier. This may be
End
treated
day
as
of the
the
placement,
commencement order.
commencement order. So the commencement order was passed when?
2016, my lord.
Where is that?
On page 25, my lord. Work order there.
That I see. Is this the commencement order?
Yes.
Yes.
Where is it? So this is on the date on which it was handed over.
Yes, my lord.
And it was terminated on 10/11/12/2019.
Yes. Yeah. 11/12/2009.
But how did you work beyond 9 months?
Because they allowed me to do the work, some extension work for us granted. I have not prepared the petition for hearing, my lord.
Huh?
Today I am on the contempt petition, my lord.
Why? That is easier.
So,
Yes, Mr. Chaudhary. These matters as to whether it could be terminated with or not. These matters require factual adjudication. How can this court look into these aspects? Yes, if it is a pure and simple point, it is there because I would have understood that you have done it in the year 2017 after the completion of it. But the fact that there has been extension, the fact that he has challenged the termination, the fact that he has also approached you, submitted bills for this period, wouldn't that be an implied extension by them itself?
No, in fact, my lord, we had granted on his request, we had granted several extensions.
So that if the extension is granted, then where is the question of the termination being bad? These are questions of fact.
Yes.
Then why should this court entertain this type of request?
so disputed question of fact is there, my lord.
Huh?
Disputed question of fact is there. That is true, but
Then what remains? We know Mr. Hussain is one of the best arbitrators, the arbitration council. So I think you should take help of those arbitration.
No, in fact, my lord, in this contract, that arbitration has been, my lord, done away with, my lord, in the contract.
Done away.
Yes.
Civil
there
court.
is no clause.
Civil court. No, there is a clause, specifically it is
Deleted.
stated the arbitration has been deleted.
So civil court.
Civil.
Because if you keep on pending this matter, almost 3 years will be over very soon.
My lord, if your lordship safeguard by this security money is 56 lakh.
Huh?
My security money relating to the other content of 56 lakh. Which
If there is some illegality, you will be entitled to interest on that.
but that is raised on independent contract.
Merely, but do you say that on the basis of an undertaking on the basis of which has been duly recorded, a right will flow to you
Yes.
for getting the right?
In this respect, my lord, I am preferring contest.
Why should I decide on all these things? When you have first, you have not been able to show anything on this main petition? The termination being good on pure, on the facts as it stands.
One judgment will satisfy your lord.
Yes, Mr. Chaudhary, when do you want this matter to be done? He seems to be not ready.
In fact, my lord, I am also not.
Huh?
In fact, I am also not fully ready.
Actually, we are on contempt remand. We are on mostly on the contempt.
He wanted to short circuit the matter by contempt.
No contempt, contempt nothing. Why should I touch on the contempt now? Look into the contempt later on. First, you have to satisfy this. On the basis of using the contempt as a tool for the purpose of getting out your money.
No, my lord, this is there is judgment. I will look with judgment.
That judgment you are ready, not with the other.
Someday convenient to your lordship, my lord.
Whenever it's convenient, tell me. Well, these 2 weeks, it's difficult. A lot of matters I've got.
No, take a date. Take a date.
Yes, Mr. Hussain, when are you going to be ready? September 12th?
Yes.
Let these matters,
Let it not be on Tuesday, my lord, any other,
Huh?
maybe 14th month.
14, okay. And taking into account that the matter would require a detailed hearing. This is the matter on 14th of September, on which day the matter will be taken up for final discussion.
Apply.
But Mr. Hussain, by any chance, I dismiss your petition on the ground of alternative remedy, on the ground that this court cannot adjudicate it.
Then
Wouldn't you have a problem because the order was passed on 11/9 and 2019.
Now, my lord, your lordship makes
11/9/2020 or 19.
termination letter.
The termination
11/12/2019.
2009.
12. The period of limitation is over. Because the writ petition can't help you. You can't get a liberty. Can you do so? Let's look into section 12 also.
Your lordship give the liberty,
Huh?
liberty to approach the
No, liberty, no. Can section 12, benefit of section 12 be, you can take if I send you to the civil court.
Proceeding in the wrong form.
You can take it. Look into it because it's a writ petition. Writ petition is not a, can't be taken as a proceedings under the Limitation Act. Find out something that
that we have.
Hello.
So many cases when the court is relegating the parties to court, civil court. And this period will be excluded.
No, that is what I am saying. Find section 12. Can the period during which you have litigated
Yes.
in a wrong forum be taken for the purpose of granting you the benefit for the purpose of limitation? Because writ petition is not considered to be a proceedings under the Limitation Act. See, there are many Supreme Court judgments on that. And if cannot, how do you take care of the limitation?
That's why we have.
So you have then enough time for almost more than a month. Yes, next. Yes, what is this? Non-payment.
The petitioner is entitled to receive certain amount of money out of execution of a SDRF schemes, my lord, under Dhemaji district, my
Hmm.
lord. Last occasion, my instruction was, my lord, deputy commissioner submitted because the releasing the responsibility to release the amount lies on the revenue department.
Hmm.
That is why my instruction was, my lord, from the water resource department.
So you have
That-
not, the DC has not sent this.
DC has not sent.
Yes, you. You have not sent that. Moreover, this department also search all the receipts, including the receipts by the department, but this department has not got any clues of.
Nothing,
However, this
particularly.
department requested the deputy to submit the same to this department for further needful by this court. Now, against this department will be request the DC to submit the same at an early date, and after receiving the documents, this department will take needful for release of the fund to the petitioner. The fund will be released by whom?
Revenue, my lord.
It is- So water resources, no business.
My lord, so far execution part is concerned, my lord.
You
there
have given no problem.
execution the part from.
You have
No,
admitted that.
Yes. DC
Now
has
the-
also, in my, to my information, my lord, DC has also issued a necessary certificate to the person.
But here it is being written
Yes,
by
yes.
the revenue on
Yes,
7/8.
true.
7/8 is what? Today?
No,
Today, in the morning. We are at
Today morning.
12:40. This was done at
Latest
10:53.
one, my lord.
Latest.
My lord, may I make submission, my lord. Either lordship can dispose it of, my lord,
Then
or
dispose it of. Let you do one thing. Let the
deputy commissioner.
water resource says, okay, he has done the work. So there is no problem with that. Now it is for the DC to send the papers
According to the, yes.
as per them. DC will send the papers and within 10 days from the date of submission of the certified copy, and within 6 months you clear the disposed. A record letter this here is kept on record and marked with the letter X. Huh? You dispose to it. Order to ekini keneke likhibo, the DC shall submit. Upor kintu likhi dibo, taking into account the communication dated 7/8/2023 issued by the Joint Secretary to the Government of Assam Revenue and Disaster Management Department. This code directs the DC Dhemaji to submit the required documents to whom?
The revenue department.
Revenue Department is some office.
Yes, my lord.
To the Joint Secretary.
Joint Secretary, Joint Secretary.
To the Joint Secretary to the Government of Assam Revenue and Disaster Management General Department within 15 days from the date of receipt of the certified copy. Full stop. It is thereupon the Revenue and Disaster Management shall take appropriate steps for making necessary verification and pay the petitioner his entitlement. The same shall be done from the date within 6 months. 6 months is too long.
No, my.
Within 6 months from the date, a certified copy is also submitted to the Joint Secretary to the Government of Assam Revenue and Disaster Management.
As well as the deputy commissioner.
That I have already stated.
Yes.
And Mr. P. Goswami appearing on behalf of appearing on behalf of the learned additional advocate general appearing on behalf of the water resource department further submits on instructions that as per the water resource department, the work was allotted to the petitioner and the petitioner has also successfully completed the work. Huh?
And DC has also issued certificate, completion.
Eh?
DC has also issued completion certificate as parting.
It should the yes, Mr. Mannan.
This matter, basically the issue is that
the petitioner who is a retired person, his pensionary benefit which is deposited in the bank was actually fraudulently taken away by some fraudsters who were ultimately arrested. And I made an application. before the
SBI,
SBI,
your money has been taken by somebody else.
somebody else. 5 persons have been arrested, fraudsters, and some in their account, some money has been transferred in their account. In the forwarding report is all stated. And then my prayer is that my amount, since I am not guilty for amount to be reversed back, and the bank can always take back the money from the fraudster. There are 2 judgments, one by the Honorable Court and one by the Supreme Court, where it is stated that if the person is not guilty, he is happy. If this person did not have even your lordship, what we say, UPI or this type of transactions, internet banking, and so he just went to the ATM to take out the money. First, he took out 9,500 on the first instance. His money was there, he have seen. Then on the second instance, when he went to take out the money.
How much is your money?
8,95,000.
Huh?
8,95,000, your lordship, that amount.
What is this comma business? You are putting the comma somewhere else.
No, that is actually shown like 8 point in the order itself. That is why they have put it like that.
Very well. Very difficult.
The lordship, I'll just point out.
Yes, what do you
Page
have? SBI you are paying?
No, I am for government.
SBI? No SBI? SBI you have made party?
Yes, yes. SBI
Where is the
main
SBI?
party. The name of the.
Oh, no SBI. Name shown. We are concerned with 6789. 6789.
Name.
Now K Das was appearing.
Yes, Kedas, yes, Ali and Kedas.
Huh?
Yes, Ali, Kedas.
S. Sharma is for part. Why are you making Airtel a party?
That part, your lordship, in fact, this is the matter I'll file by earlier some other accounts. But I also am not pressing anything against him. I told him, in fact. Because Airtel, Bharti Airtel was actually not, because what has happened is basically SIM swapping has happened. My SIM, somebody else took my SIM by doing some fraud. They swapped the SIM, my SIM number, because that is why the messages have not come to.
Yeah, the payment did not go through UPI. Because there are 2 types of matter. One is a matter by which I passed the order in Justice B.D. Agarwal's judgment case, which went in the division bench. Division bench has also approved that. There's another case by which was passed by brother. Yeah. There's another case, but that is by SBI.
Justice Suman Sham Pasmat
Ah,
in advocate Pallav Bhaumik's case.
yes, but
Yeah,
there
and
we
the-
have.
And the Supreme Court
I
judgment
sitting
was-
out there in the division bench have granted a stay in that matter, taking into account that the payment, there was an amount pertaining to some 90,000 or 1 lakh to that effect.
Yeah.
This amount was taken on the basis of OTP being given.
Yes.
Now, in your case, whether
In my
any,
case, just one moment, page 29. Page 29. This is the reporting report of the accused persons who were arrested. Your lordship will find ground of arrest part. During the investigation, it is revealed that the arrest accused are hardcore cyber fraudsters and gang of organized crime since many years and are involved in stealing of hard-earned money of victims and deferred funds of income. During the course of investigation, the transaction statement of the complaint were analyzed, where the involvement of the accused revealed. During the investigation, revealed that accused number 1 and accused number 2 were found expert in the method of phone number swap process, where they swap the mobile number of the complaint being so and so by preparing fake ID proof, and thus they fraudulently transfer an amount of so and so 9 lakh so and so from the account number during the period 210 to 1010. During investigation, primary evidence have found
I understood, but what are these people saying? This is all your
this
DCRG
is what
amount
has
has,
come
your
out.
DCRG amount has been taken. Huh? It's all
Yes,
your,
yes, yes, this year, yes. That amount was deposited 9 lakh something. I have taken out 9,000 or I think twice, 9,500. Then the rest were taken out. It is only 67 rupees remaining.
What does the bank say, SBI?
Bank filed an affidavit, Your Lordship.
What is their stand?
They have taken a stand that in paragraph, mainly paragraph 7, page 3 of the bank's affidavit.
The details of the registration is available.
In fact, they have stated that I have compromised the PIN, but in fact, in my statement, I have stated that my phone, in fact, the police have also stated that my phone number, phone SIM has been swapped. So whatever PIN went to them.
Now, Mr. Manan, there is one circular. Where is that? They have a circular. This SBI.
Which circular?
Huh?
Which circular?
They have a circular. How, where the payment has to be made, how it is to be made, when they are to stop, and more particularly clause 7. You have to get that. There you will find out how it is to be done.
In that circle,
SBI
circular.
SBI. They have
Or it is
one.
the RBI circle.
The RBI is something, but SBI does it.
Okay.
Means if it is absolutely fraudulent, you are entitled, which they have not mentioned anything here. You get all of that. So taking into account that the SBI is not represented before this court, list the matter again on when.
Absolutely. Anything.
Well, you have no urgency. You will have it after October vacation.
No, I can have it this month.
Huh?
This month, if
Okay,
possible.
we'll have it on 28th of August 2023. So in the meantime, Mr. Y.S. Manan, the learned counsel for the petitioner. In the meantime, this court directs the SBI, the council directs the councils appearing on behalf of the parties to produce before this court any RBI circulars as regards the bank fraud, huh?
Yes.
As regards fraudulent transactions through fraudulent transactions
Here it is specifically UPI and internet
through fraudulent transactions relating to UPI as well as internet banking. Huh? 22nd.
25.
You want it before? Why? You have nothing to do. Ask some junior of yours to be present. Yes, next.
He'll have to be present. He'll have to be present in RTI.
But it is rejection of the transport subsidy claim by the SLP.
Lordship,
My lord, if your lordship counts, my lord,
Lordship, in these two matters, Lordship, I haven't received the instructions, Lordship. I need to file an affidavit.
He's claiming transport subsidy
Yes, Lordship.
of 1 crore 73 lakhs. You pay interest also.
Interest, lordship, that issue is pending. I mean, that as far as like subsidies are concerned, whether interest will be allowed or not, that is pending before the Supreme Court.
Okay, we also pass orders that you pay interest, not from the government coffers, from your, who is that officer?
Lordship,
Who is delaying it?
lordship, actually,
Who is
I,
delaying the filing of the affidavit?
lordship, may kindly allow me a week's time, lordship.
I'll record it, that any interest to be paid will be from the salary of that person concerned, which is
Lordship, actually, I have
from
written.
the secretary, commission and secretary industries department.
Lordship, 1 week time may be granted. I'll file it.
Yes.
1 week.
Why haven't you filed it? Notice was issued on 7/12/2021.
Yes, lordship, yes, but I have written on 18 March 2021.
Notice was issued on 12/3/2021.
Yes, lordship, I have
Then-
also, like, 18th March, I have written.
And your name glaringly appears out there and accepted notice.
Yes, yes, lordship.
Then-
I have written letter to them also, but like somehow I haven't received it. Just give me 1 week's time, I'll file an affidavit.
Yes.
I have written on 18th of March itself.
Mr. A. Kolita appearing on behalf of the petitioner, on
Respondent.
behalf of the industries department, submits that within 1 week from today, the affidavit would be filed on behalf of the industries department. Mr. G.N. Sahavala, the learned senior counsel, drawing the attention of this court to the order dated 12/3/2021, submits that the notice was issued on that day when an amount of rupees 1,73,05,865 has been withheld by the respondent authorities and thereby causing severe prejudice to the petitioner. Taking into account the above, let this matter be again listed on 21st of August 2023. The respondent in the industries department shall file the affidavit by today, by 16th of August 2023.
16th, lordship, 16th.
16th. It is however made clear that if no affidavit is filed, this court shall proceed to dispose of the matter on the basis of the materials available in the court.
Published it.
Plus the another matter is also there on
Where?
Same, lordship, same.
23.
Similar matter, 2020 to 23. So this,
এইটো
other one
20
also, I
আগৰটো
will file
এই
it.
23 টো চাওঁ। এইটো আৰু অকমান দিওঁ, এইটো সময় কমাই দিওঁ। Oh, this is the 19.
Lordship, sir, both the matters can be taken up together. I'll file
Wait,
an
wait, wait.
affidavit.
Claim is 34 lakh and all.
Amount is how much?
34 lakh 27,660.
34 lakh, huh, itu? 34 lakh 27,662. Huh? Itu file koriba, আৰু এইটো this is a notice was issued on 22/7/2019.
Lordship.
Yes, Mr. Haq.
The petitioner's land has been utilized by the PWD department for construction of RCC building, RCC breach matter, without acquiring the land. Then we file it.
Petitioner is what do they want? Set aside and cancel the construction work of the road and bridge over the petitioner's land measuring so and so, direct response to make an inquiry compliance with so and so, direct so and so. So upon your land,
Right.
they have encroached.
It got constructed, my lord, RCC, not constructed, started construction of RCC bridge,
They're on your road.
on my land,
They have already done
not completed, my lord, that construction has been stayed.
their land.
My lord, obviously, if we are building a road, my lord, that is for public use, not for, and requisite compensation will be paid, my lord. If
No,
it is
no,
the-
no, no, no. Acquired? Have you acquired the land?
My lord, acquire that DC usually.
Would you
does it
like,
and-
Mr. Dhar, in your house, you have a plot of land somewhere at the PWD, when you are no longer there in the PWD, some person comes over and says that, okay, above this house, that house, let us break it and make a breeze out there. And then Mr. Hawk appears for the PWD and says, look here, Mr. Dhar will get compensation. You like that? You can't do that.
My lord, acquisition is usually done by the DC. Acquisition part. We are executing body, my lord, we build.
Are you saying that the DC has done without acquiring have done this?
That part, my lord, will have to ascertain, my lord. Because, my lord, if
No,
you go by
first of
this
all,
page,
notice was
pa-
issued
pa-
on
page num-
7th.
page number
No,
37.
Mr. Dhar, notice was issued on 7/4/2021.
My lord.
No affidavit has been filed. You have no instructions also. And madam, you are appearing for the DC. Have you acquired anything? Petitioner's land. Then, what is this? We pass direct that no, nothing you can't do without going for an acquisition. And whatever you have built, you demolish it and pay him compensation for that. Or you demolish it at the risk and give him a bill. They will pay. Okay. The instant petition has been filed.
My lord will grant us at least 1 week time, my lord. Let
For
us
what?
See, my lord,
No, you demolish it at his cost and do whatever and the amount, whatever you claim they have to pay.
my lord, the thing is
And
that
also, what will be the amount you are liable to for use of the land you have been deprived?
my lord will go to page number 37.
What is that?
My lord.
What is it? Tell me.
My lord, it's a letter to the executive engineer by the additional district magistrate, my lord.
Hmm.
Here he says that there is a public complaint, my lord.
Hmm.
My lord, we have to ascertain his claim is whether correct or not. That part, my lord. So, my lord,
No, no. Why you haven't done it? This was on 7/4/2021. There's a stay order and they have stopped pursuant to this. And then you are not interested in any further.
It is not a complaint, it's a complaint petition, not complaint.
There's no complaint. It's a public complaint.
It is public submitted by me.
Not to hear with the public complaint. Don't make all these things.
my lord will grant me 1 week time, my lord. I will file
And the
affidavit, my lord.
DC is not bothered out there. How does the DC do all these things? Which district?
Borpeta.
My goodness. Mr. Ardhor and Miss MB Burman appearing on behalf of the PWD as well as the Deputy Commissioner Borpeta, respectively, request for an accommodation of a week for getting instructions and or filing their affidavits. List the matter again on 21st of August 2023, on which date the learned counsels for the respondents shall apprise this court in respect to the, as regards their instructions in the matter. The interim order passed earlier on 7/4/2021 is extended till the disposal of the petition.
I've taken instruction, your lordship, with this for the file. Your lordship, the presentation was submitted, your lordship, and thereafter show cause notice was issued. And there was no response to the show cause notice. Thereafter, the warrant was issued. But there are two separate liabilities which I have come to learn, your lordship. Because one is my friend, he is appearing for the Apex Cooperative Apex Bank, your lordship. That is under the SARFAESI Act. And the earlier one, your lordship, the Pakisai case is from before, your lordship.
You are appearing for?
I'm for a corporation department, your lordship.
You are paying for the corporation.
Corporation department. So I am for the Bakizai officer and the RCS, your lordship. And they had some liability with the cooperative society, your lordship, which is respondent number 5, your lordship.
Who had the liability?
The petitioners, your lordship.
No, petitioner had the liability or the company had the liability?
The company, your lordship, from what I can make out from the petition, your lordship. They had
If the
liability with
company had the
agro-
liability,
Yes, your lordship.
then how can they proceed after having known that the management has been transferred to some third party?
The proceeding was going on from earlier, your lordship.
Understood.
Vakizai proceeding.
Understood,
Yes.
but in the meantime, just for
Yes.
example, in a suit or any other proceedings out there, if the particular company or the management is being taken over,
Lord.
can the petitioner now act or do anything on behalf of the management? Because he will be doing on behalf of the management.
Yes,
Can
sir.
he do so in the proceedings?
Lord. To that effect, I will have to, your lordship, if your lordship done me some time, your lordship, because the representation was submitted and the petition is not with the department also, your lordship. So if I can get some time to get the parawise reply, your lordship. Meanwhile, I can get the records also, your lordship.
Because that is the issue.
Yes, your lordship. Because they have
Because
submitted a
the
representation. that is
proceedings
there.
was against, not against him. The proceeding was against the company.
Okay.
Now the company is done. A company happens on the basis of a management, the board of directors.
Yes.
And the director shall be responsible.
Yes.
Now, can he take any action
Lord.
on behalf of the board of directors after the exercise of powers under section 13(4)(b)? If he can't do it, then you can't pass an order against him personally. You can pass an order against that company and the persons who are responsible in the company for that purpose. It may be the bank. The bank may be there because the bank has taken over the management
Yes.
and given it to some third party.
Third party there,
So it is the bank who may be responsible for that.
Lord. But some time maybe down to 1 week time, your
Yes,
lordship.
Mr. Pathak.
Otherwise, they are having interim, your lordship. They protect.
Understood, they have an employing, but does it mean that a repetition will be pending for 5 years for this small?
Lordship.
Yes, Mr. Pathak.
There was another
You have
earlier.
taken over the management.
Yeah.
Once you take over the management, you have appointed some managing agent on your behalf.
On our behalf.
So now the management of the company is with you or your managing agent. So any Bakizai proceedings now has to be proceeded against the company. Because the Bakizai proceedings was initiated against the company.
Your lordship, there is a writ petition in annex. I think there was another earlier writ petition. I just had the occasion to go through the brief. From the pleadings, it appears that the certificate, your lordship, was in person against the petitioner, your lordship, not against the
No,
company.
liability is who against who?
Liability, I think, is of the company, but the
So if
certificate
the
was issued
liability is against the company,
company.
so the company, and you see, the notice was issued on 14/3/2018.
Yeah.
Prior to that, the bank has already initiated the proceedings under the Surface
We
Act
have,
and taking over the management.
we have.
So I think the SOCO's notice is the initiation.
Yes, your lordship. The certificate perhaps would be the initiation, your lordship. Once the certificate has been issued,
Certificate is against the company.
it's against the petitioner in person, your lordship.
How?
His name, not against the company. That's what it appears from the pleadings, your lordship.
Show me the certificate.
The certificate perhaps is not there. I'm reading from page number 52, your lordship. of the writ.
Yes.
The last paragraph on the bottom. On failure of the said company to discharge a liability, respond number 5, in all probability made written requisition to respond number 4 for recovery of the loan advanced to the company of the petitioner within the meaning of section 70 of the Assam Cooperative Societies Act, since repealed by the Assam Cooperative Society Act 2007. The respond number 4 determine the outstanding loan payable by the petitioner's company and non-payment thereof by the company of the petitioner at the relevant time. Respond number 4 send the requisition to respond number 3, and on receipt of such requisition, respond number 3 issued a certificate of public demand dated so and so 19/1/2009, asking the petitioner to make the payment of rupees so and so in total, and the said certificate is registered at 19/1/2009.
Page 71.
It's 71. 71, yes, your lordship. Some of the register
Kindly page C, page 74. Last slide.
Yes.
So it is the managing director of the company who is the certificate debtor.
Whether it's in his role as managing director or it,
Can be, we have to see the certificate as it is. Kindly see page 73. 26, 28, 6, 2009. The representation of the certificate holder is present. Dr. So-and-so, managing director is present for the debtor. The prayer is so-and-so, so-and-so. The certificate debtor did not supplement any paper, so-and-so, so-and-so. So it is the company who has to pay. If the company has to pay, then the notice has to be issued when it has been duly brought to the notice of them.
but perhaps these proceedings, Your Lordship, since they had these particular proceedings, since they had been initiated prior to the taking over of the company,
Understood.
and it's
But it is against the company.
against the company.
The moment it is against the company, the certificate debtor is the company.
Lordship,
Then in that case, when this aspect was duly brought to the notice
Lordship.
by the communication dated
Yes, it was.
by the communication dated 24/1/2017
Yes, sir.
from the ex-managing director bringing to the notice that the bank has already taken and appointed so and so. Then why this notice, the show cause notice was issued to the managing director? This is the basis.
Yes, this is the basis.
When the certificate debtor is the company. Because if you see the SURFACE Act, the earlier management cannot act on behalf of the company after.
Yes, they cannot.
So if they can't, you can't impose any liability upon them also, whatever it may be. They may have a liability, that might be the liability which the bank may try to also take into account for the purpose of in pursuance to the SURFACE proceedings. You take whatever may be
Lord.
on the basis of that, maybe.
Perhaps since section 15, Your Lordship, is only intended to satisfy the debt of the bank, Your Lordship.
This is the bank of the debt.
No, this is not a bank. We are the bank.
They are
They are just a regular property society.
So this is whatever may be that certificate debtor being the company.
Yes, but perhaps whether it's previous debts, Your Lordship,
Why not?
which
No, you have to proceed against that that particular company.
no, because but management was taken over, Your Lordship, only for the purpose of satisfying the debt the bank has against the company, Your Lordship. Now, if we take over, we have to, Your Lordship, satisfy other debts as well, Your Lordship. Then perhaps that would not
Now,
fulfill the
tomorrow he comes over to the circle to that particular Bakija officer and says, then look here, I am ready to pay all these things. I am appearing as the managing director of this company, and the company will pay within 10 days.
which you cannot do now.
He can't do that. It has to be done because he can't bind the company then after the exercise under 1340. He can't bind anything. And if he can't bind, how can he make any payment? And would that payment be taken into account as the payment on behalf of the company? You can't. He'll be happy enough to get it. He will be happy to get the money. That's a different thing. But can he bind it? No. Isn't that not your argument?
Yes, that's precisely. In fact, my lord, the initiation of that liability was because of a loan agreement. And that loan agreement was entered into by the company. That is also on that.
No, therefore, the certificate, if you see the certificate
Also matches.
is the company.
Since my net friend is otherwise seeking time to file a short affidavit, perhaps we may also be allowed some time, short affidavit, a week's time. Just so that our stand is on record. Just so that our stand is on record, your lord.
But for the responsible seven, who would now have
Yes,
to
otherwise-
shoulder the liability. Responsible seven, managing agent, which has to now shoulder the liability. That is also, they are also represented.
Right?
I'm representing person number 7.
Yes, what do you say about paragraph number
Uh,
7 of the affidavit of the agreement? Paragraph 7 or 6? Paragraph 4 or 7
Not regarding-
of that agreement?
Yes.
What do you say? Did you say that past dues you will take care of it?
Regarding the Bakija amount, your lordship, we are actually ready to pay the amount. I have the instruction to say that if it's regarding the
You put
Bakija
it on
amount,
affidavit,
okay, we'll file an affidavit.
list the matter on 21st of August 2023, on which date the respondent, what's your name, madam?
And Mahanta,
Ms. M. Mohanto appearing on behalf of the respondent number 7
Seven.
submits that in view of clause
Four
that agreement,
Page 35.
view of clause,
4, page 35.
clause which one?
Clause 4, Malad, last part.
In
And
view
all-
of clause 4 of the agreement dated
20.
23rd of July 2015 between the respondent number 6 and respondent number 7. The respondent number 7 is willing to pay the amount pending, payable in terms of the Bakizai proceed, in terms with the certificate issued against the company, namely MS Ananda Tea Company. This court finds it relevant that the said aspect of the matter be brought on record by way of an affidavit. List the matter again on 23rd of August 2023. In the meantime, the respondent number 7 is given the liberty to file the affidavit. Further to that, the respondent number, the corporation department as well as the Assam Cooperative Apex Bank Limited is also given the liberty to file the affidavit. These affidavits be filed by 21st of August 2023. It's the-
All right.
Take leave.
They file an affidavit. They file the affidavit. We don't know whether it's on record or not. We'll have to respond to that because what they've stated is that on the day when the notification was passed,
Hmm.
directing, taking of those cardholders of FPS having less than 50 and less than, I had, the petitioner had 50 numbers of cardholders. That is what is said. But that is, we have conferred with the petitioner. He says that she had more than 50. She had 51. She had more than the requisite number. So we'll have to place
But the decision was 50 and above.
50 and above. Yes.
Then how does it affect you?
No, I had 50 and below were required to be tagged.
Is
50
it?
and below. Yes. Above 50 were exempted.
How many were there?
They say they have annexed a statement saying that we had 50 on August 2021.
Anyway, you are widow, no,
No,
you don't come within the
no,
exceptions.
not within that second notification. We do not come, we do not get the benefit of the second notification.
The exceptions you don't
No,
come.
no.
So you come under that, you have to have 50.
Yes, 51, not 50. 50 is 50, you have to be 10. 50 and below.
Ms. E. Buragai, Borgohai, the learned counsel appearing on behalf of the petitioner submits that in view of the affidavit so filed by the Commissioner of Food and Civil Supplies, Consumer Affairs and Legal Methodology, Assam, the petitioner would like to file a reply. How much time?
2 weeks.
He submits that 2 weeks' time may be granted in that regard. List the matter again on 28th of August. Yes, madam.
My lord, in this case, no copies were served to us, my lord. We could not send a notice, my lord.
Directing the
So far as his prayer is concerned, he want a direction for consider his representation dated 7/12/2020, my lord.
The instant writ petition has been filed seeking a direction upon the respondent number 2 to consider the representation dated 7/12/2020 filed by the petitioner. A perusal of the said representation shows that the petitioner had requested the respondent number 2 that if any steps are being taken for acquisition and excavating his periodic patta land for the purpose of installation of geobag, he may be given an advance notice taking into account the limited stand in the instant writ petition. This court disposes of the instant writ petition with a direction upon the respondent number 2 to take steps in terms to, yes,
Yeah, for the petitioner lordship. Or in this case, we need some time to file affidavit lordship.
dispose of the instant writ petition, directing the respondent number 2 to take note of the representations so submitted on 7/12/2020, and if any right of the petitioner is violated, the respondent authority shall do so, if any rights of the petitioner in respect to his land is being affected on the basis of any orders being passed by the respondent authority or disposing of the with a direction to the respondent number 2 that before taking any steps whereby any right of the petitioner is affected, the petitioner may be given an advance notice, the above the petition.
May please, your lordship.
Yes,
Lordship, the respondents have been occupying as tenants the subject premises of the petition. These facts have been admitted, your lordship. Annexure 1 shows at page 12,
Mr. Counsel, why should this court decide all these things?
disputed question of fact, your lordship, I understand, but in certain cases, if I may rely on the case of Kunwan for another,
For what?
in certain cases, your lordship, the High Court has the jurisdiction under 226
For?
to go into the question of fact if
The instant writ petition has been filed seeking a direction upon the respondent authorities to pay the area rent of rupees 2,55,732, which has accrued upon the petitioner from September 2016 till the date of filing of the writ petition, along with 7% interest per annum. It appears on record that this court had issued notice on 14/7/2021. And the order of the Lozima Court dated 19/6/2023 shows that the service upon the respondent numbers 1, 2, and 3 are complete. From a perusal of the above writ petition, the claim so made is on the basis that the respondent numbers 1, 2, and 3 are in occupation of the petitioner's land, petitioner's house, premises, and the said respondents have not made payment to the petitioner, for which the instant writ petition has been filed, seeking a direction to the said respondents to make payment of the area dues to the amount of rupees 2,55,732, along with interest at a rate of 7%. The fact as to whether the petitioner is entitled to the amount of rupees 2,55,732, or as to whether the respondent or as to whether the petitioner and the respondents are in occupation of the premises of the petitioner cannot be ascertained in the instant proceedings. Be that as it may, it is however relevant to take note of that if the respondent numbers 1, 2, and 3, which is a state authority, which is a state within the meaning of Article 12 of the Constitution, is in occupation of the petitioner's premises, the said respondents are duty bound to make payment of the dues to the petitioner. Under such circumstances, the instant writ petition is disposed of with a direction to the respondent numbers 1, 2, and 3 to verify as to what amount the petitioner is entitled to. Since September 2016, in respect to the premises of the petitioner, and upon verification, if any amount is found payable to the petitioner, the same be paid within a period of 6 months from the date a certified copy is served upon the respondent number.
Lordship. The pattern will pass for that.
Huh?
Pass for that.
Why?
So my
What
finger
is,
not
what are you
able to
asking for? See, so many lawyers are appearing. And you are asking for Passover? Setting aside the letter issued by referring the matter to the President Ruposi for holding the setting aside and quashing the impugned letter dated remand issued by the executive for holding the setting aside the impugned resolution dated now convening expressing no confidence against the allowed President to grant any other relief. So you have got a stay.
Yes.
What is your ground? What is your ground?
Is piloting the 15+1.
Yes, what is his ground? You are appearing for whom?
Respondent number 7.
Then?
On behalf of G. Bordoloi. Lordship, we have hand over the brief of the case to the client, so.
At the request of the learned council, matter stands adjourned till 11th of September. The respondent, the private respondent has no objection to the same. The interim order passed earlier shall continue till. Yes, what are you asking?
This is regarding my lord, amnesty for road accident, my lord. As per notification dated 15/11/2014, my lord.
This is for excellent.
Ex gratia amount,
Ex
amounting.
gratia.
Okay, verify. Pay. Dispose.
Published.
Your order, can I? Mr. AFNU Mullah, give your name. Yeah.
Your lordship, the matter will be kindly adjourned for the day as the case not allowed to be.
Why?
Please.
Okay.
Yes, Mr. Goswami.
My lord.
This land you have taken?
No.
Huh? You have not taken the land?
Yes, because the present scheme was executed for the purpose of raising and strengthening the existing embankment.
So there was no acquisition.
No acquisition. That is there was no acquisition.
You
Because
filed an
there was a embankment dike. On that it was constructed.
Some affidavit filed with. There's some land acquisition.
Yes. No proceeding was there, land acquisition proceeding.
Additional affidavit filed. You have filed some affidavit, no?
Yes.
What Asuni? What? These are LA cases and all, these are different lands.
Possibly, madam.
What is that? 54. 54. Joint affidavit. Deputy Commissioner, you are there?
Here, my lord, the Deputy Commissioner for the same.
Deputy Commissioner, you file an affidavit as to whether there has been any acquisition or not in respect of the petitioner's land. Ms. M.B. Cormon appearing on behalf of the respondent number 2. Is directed to file, the Deputy Commissioner, taking into account the specific stand taken by the Chief Engineer, Assistant Chief Engineer, Water Resource
On behalf of Chief
Department.
Engineer.
Huh?
Let me say Chief Engineer.
No, here it's saying that I'm working as
Yes,
assistant.
he's in the office of the Chief Engineer.
Taking into account the affidavit in opposition filed by the Chief Engineer, Water Resource Department dated 31/10/2022, wherein it has been mentioned that the land acquisition was not required in the left bank embankment, as it was a scheme executed for raising and strengthening the works over the existing embankment. The land acquisition under dark and pata numbers did not arise. This court directs the Deputy Commissioner Morigaon to clarify by way of an affidavit as to whether the lands whether there was any acquisition carried out in respect to the lands mentioned in paragraph number 2 of the writ petition. List the matter again on 30th of August
In
2020.
connection with the scheme.
Saying it out there, paragraph number 2 at the,
Yes. Because they have referred to the scheme.
in respect to the scheme in which.
Lordship, in this matter, Lordship, proposal has already been sanctioned, Lordship. I have received a copy of this today morning. I have submitted a copy. Lordship, today morning, I have received a communication from the Executive Engineer, Mongoldoy Water Resource Division, where it has been stated that administrative approval to the scheme land acquisition for the project construction of marginal embankment in both banks of Ghagra River from Patgiri Suba to Duni Patharighat PWD Road, extension of Ghagra embankment from Tengra village to Samukha village from CH0M to 4500. Already administrative approval has been given for
land acquisition.
it.
Then
Now, along with the Deputy Commissioner, they will have to sort it out. So,
good. List ko. আর ওখানে ছিল না ক্যালেন্ডার এখন ক্যালেন্ডার কত Mr. R.M. Das, the learned counsel appearing for
Water Resource Department.
Water Resource Department submits that the proposal for the administrative approval in respect to acquisition of the land in question have already been passed, and as such the respondent authorities are actively taking steps for the purpose of acquisition of the land in question. Taking into account the above, list the matter on 4th of October 2023 for update as regards the acquisition process.
Lordship, to the fact, Lordship, as for far as I understand. So, my land acquisition in the 4 bigger 15 lakh. Yes, but-
Mr. Das, we will consider that.
Yes, Lord.
Let them have some acquisition, then we'll see. At present, we can't do anything.
20 years has been going on, Lordship. Not a
Huh?
single penny. 20 years has been going on. My land is secured. So as on that, I have not received any kind of thing.
You'll get it now when I'm taking it.
Yes, sir. Pass away.
Yeah.
Your lordship, I'm for the respondent, your
You
lordship.
file your affidavit.
No, your lordship.
You're filing it?
Yes, your lordship. Actually, the all similar matters are fixed on 22nd of August, your lordship.
That day, one matter has come now.
Yes, your lordship.
That matter was listed before me. The Mr.
Yes, yes,
Madam Havelia was doing that
Yes,
matter.
yes, your lordship. Lordship,
Where is that?
My lord, this is
You are referring to that judgment? Notice high tech.
Yes, my lord, your lordship will pass this order.
I know that.
It is
Not necessary.
the same issue, my lord.
No, it can't be same issue. You will have to also see the
Yes,
facts.
yes.
Isn't it?
Yes, your lordship. Lordship, sometime may be allowed, your lordship. We will file affidavit.
When is the other matter fixed? That day I fixed some matters.
I informed that on 22nd of August, all the.
Okay, list the matter on list this matter, Miss, your name?
Ardeka.
Miss Ardeka appearing on behalf of the Central Excise?
Yes.
Central Excise Department has submitted that similar matters are pending, which is fixed by this court on 22nd of August 2023. So taking into account the same, that's the list this matter again also on 22nd of August 2023. In the meantime, the respondents could be at liberty to file their affidavit.
Obliged.
Yes,
Whatever. I'm making my submission document, I'd like to narrate the facts of the case structure.
what is the matter about?
But if we are challenging the order in original passed by the principal commissioner, CCFM. But what has happened, what is the petitioners hearing are engaged in construction related services.
Hmm.
They have separate registration for the state of Arunachal Pradesh as well as. state of
You are
Assam.
challenging a show cause notice.
What is Chokos notice as well as the subsequent order in origin.
Then why should this court at all entertain this?
But if there are allegation of violation of fixed laws of natural justice.
Hmm?
Allegation of natural justice is there.
What is this violation of, you have been issued a show cause?
Notice, Chokos notice was issued and eventually lordship we were given personal hearing notice. We replied to that seeking further time to produce the document. Then lordship, because there are two certificates like in computing the demand of service like lordship, it seems that they've clubbed together the income derived from both sources. So basically we thought.
So can't you raise all these things in appeal? Why are you raising it out here?
Because we were not provided an opportunity of hearing.
What is this? You have been issued a show cause and what else do you want?
Lordship may kindly come to.
You should have the hearing out here at your residence.
Okay, we have filed affidavit, your lordship. We raised the ground that we have not availed the alternative remedy,
Ah.
your lordship.
To establish my fact argument about the actual justice, lordship, I may take your lordship to the affidavit in opposition filed by them.
Hmm.
Lordship may kindly come to page 87.
Page
87.
87. Yes,
Okay, paragraph 7.
yes.
Second part. In the letter dated 3/2/2021, which we have submitted. They have
Here we go.
requested to grant reasonable time to prepare the documents and to appear for personal hearing. However, intimation of the fixing of the next set of personal hearing was already sent by so and so. Since the earlier personal hearing notice was delivered to the petitioner, it is conceived that the notice dated so and so too has been delivered by the postal office. But in support of that, they are just assuming that we have received the notice. On this statement, lordship, it seems that they have assumed that we have received the notice. They have not provided any supporting documents. And we are contending that we have not received the subsequent notices.
So a notice of hearing was given,
Notice of hearing was given. We
but
had-
you did not receive it.
Lordship, first hearing notice we received, we had replied to that, seeking some further time. We have given particular documents also. But we sought for some further time to produce the other documents that is necessary for the adjudication. So that those subsequent hearing notices were not received by us. So the only grievance, lordship,
But was it sent to the right address?
they are saying that because we had received the first notice already, so the subsequent notices are deemed to have been received by us.
Then
But there is no postal, any endorsement by the postal authority.
how did you send it, madam?
Also, in the earlier address, your lordship,
How?
earlier address, they have
How?
received, your lordship.
How did
By
you
post,
send?
your lordship.
By post? By post means how? Means normally, in what manner do you send?
Normally, lordship register post,
Send it by. So you don't have the receipts?
maybe a lordship, I have to take instruction.
At this point, I would be very lordship. If satisfied, there is a violation of natural justice, may just remand back the matter to bench.
From the affidavit in opposition filed by the respondents, it transpires from paragraph number 10 that the first notice for personal hearing was issued to the petitioner on 11/1/2021, asking the petitioner to appear before the adjudicating authority on 27/1/2021 at 13:15 hours. On the basis of the said notice, the petitioner had duly appeared. Thereupon, there was an intimation further issued for personal hearing by another notice dated 2/2/2021. It further transpires that on the basis of the second notice, it further transpired that the concerned respondent authorities have construed that the said notice dated 2/2/2021 was duly received by the petitioner and delivered by the postal authority on the basis that it was sent in the same address as was done on the earlier occasion. This court made a specific query upon the learned counsel appearing on behalf of the Central Excise Department as to how the notice was sent and as to whether there is any documents to show that any notice to that effect was sent by way of registered post and any postal acknowledgement being and any document to show that the any acknowledgement and as to whether there is any, what is that you call it, particular thing, delivery, postal delivery report in that regard. Miss So-and-so, the learned counsel appearing on behalf of the Central Excise Department submits that she would take necessary instructions in that regard. List the matter again on 28th of August 2023. Interim order passed earlier shall continue. Because otherwise, madam, these small matters keeping out here, these matters needs to be finished up. You go and first decide, asking them to appear on that date, and then you decide whatever may be. Keeping out here from 2021 is in fact, there's a stay which is prejudicial to the interest of the revenue. So these matters needs to be disposed, setting it aside and asking you to do it and asking him to appear on a particular date. I think that is the best course of action. Anyways, next time if we don't get it, I'll pass that on. Yes. Forest. Why is Forest not filing affidavit?
I had some instructions from
Or you are
otherwise.
getting environment friendly?
No, my lord, this person, though he canvasses a case of not my lord resorting natural justice, my lord, before terminating him, I have been instructed, my lord, this person has been contacted mobile and he is not residing here, my lord, he's from Rajasthan.
My lord, what happened, my lord, similar matter, my lord, same matter, same disposal by this another code of this court. They alleged that there is a violation of natural. So this.
That was I considered, my
blacklisting, that means like a penalty, my lord, I was debarred from participating in tender process for 5 years in entire Assam. That was without notice. That is the only challenge to the order matter. Your lordship may kindly take item number 35. Because your lordship.
How many matters are there?
2 matters, 35 if your lordship said, then 34 may not be called. 35, your lordship will see the improved order, page 74, madam.
Eight,
74, madam.
74.
Yes.
Settled with Kallas Jalan is hereby terminated consequent upon default and failure of payment of Swens. He debarred from granting any French transfer for 5 years.
Yes.
No, further an amount of it. So you say that this order was passed thereby debarring for 5 years is without principles of natural
Yes, and
justice.
similar order is being passed.
Similar order. Then
Yeah.
why have you filed the second writ petition?
No, I am not in respect of this stone mining, another mining. area. This is stone mining area C, madam. That was another mining area. They passed the order, madam. The lordship will.
Yes, did you issue notice?
Madam, my instruction are there was notice was issued, madam.
Fantastic. File an affidavit if you have done it.
Madam,
When?
2 weeks, madam. Oh, I can produce the records because records will be more convenient for me, madam.
This is of 21, madam, June 21. Thereafter, they are sitting, madam, for last 1.5 years. Now subsequent tenders are coming up, madam, and I have been deferred. Only thing is that if they give natural justice, this order may be set aside, they may take a decision. This,
Have you mentioned this matter earlier?
madam, there is another.
Why are you sitting out there
No,
idle?
my lord, actually fairly, my lord. This case was pending before another court, my lord, and that order was not uploaded, my lord.
That may not be gone into. that. Other aspect.
I have pursued my lord lawsuit. Anyhow, my lord. Only thing is that if they give a re-hearing to me, my lord.
Rehearing means,
okay,
my lord,
no
he has been
problem.
heard.
You do one thing. You file either an affidavit or yeah, we are having it on 21st.
22nd, madam.
21st.
21st, I have to.
Why?
I'll be outstation, madam.
So ask, you have many forest.
I'll ask Pathak.
Ask anybody.
Well,
This court by an order dated 29/10/2021 had issued notice and further observed that on 1/12/2021, the interim order shall be taken into consideration. However, the matter has been listed today after almost 2 years. Taking into account the above, taking into account the submissions of Mr. B. Borua, the learned counsel appearing on behalf of the petitioner, who submits that the order impugned in the instant proceedings have been passed without following the principles of natural justice. This court and that the petitioner is suffering as he is not in a position to participate in future tenders. This court directs the forest department. This court directs the registry to list the matter again on 21/8/2023. In the meantime, the forest department the forest department shall obtain necessary instructions in the matter along with also produce the records on 21st of August 2020. Yes.
This is a similar matter as item 32.
Oh, that one. এই আইটেম number 32G order দিছিলো তাৰ লগত একেই
There's an interim order.
interim order till then 32 আছিল নে interim order
32.
32.
there was an interim order. What is that interim order?
Not to take any coercive action. All right.
All right.
Ah
matter, I need a few weeks' time for instructions.
Now let us. Yes, tell me. What do you say about Rule 18? You don't have to say. You take your seat. You don't have. Yes, now let us hear what he says. What is this? His land, you are doing all these things.
Here, if my lord may be pleased to come to page 21. Page 21 of the petition. The petitioner is the owner, my lord, of 1 Kotha 3 letter.
Mm.
That is, my lord, under Dag number 108 of Kotha number 24.
Mm.
And this plot of land came into his ownership by dint of, my lord, conversion of annual patta land to Miyadi patta,
Mm.
whereby, my lord, a separate patta has been issued to him.
Mm.
Leaving aside, my lord, a plot of land measuring, my lord, 10 lesser.
What is Annexure 2?
Yes, Annexure 2 pertains to 10 lesser.
Ah.
The 10 lesser which was left out in the earlier settlement,
Mm.
that was again, my lord, settled with, my lord, the petitioner.
Mm. So
There-
he has 1 Katha 13 letter.
1 Kotha
In
30,
Dag number 107 and 108.
107 and 108. Of course, my lord, in page number 24, lordship will find that the patta number is different.
Hmm.
Patta
Okay.
number is 144,
So these two, but I think it must be the conjoined land.
contiguous.
Hmm.
Now, lordship will come to the impugned notice at page 36.
Hmm.
This has been issued by the circle officer.
Yes.
Now, so far as jurisdiction of the circle officer to issue a notice under 18(1), my lord, there is no dispute, my lord, he has the authority. Now, so far as, my lord, the schedule of land, that is absent here. But I find also from this notice,
Hmm.
it only says that it says, my lord,
That he is in occupation of National Highway number
yes,
515.
yes, without there being any
There
identification.
is no schedule, no Dag, nothing.
Nothing,
Then what
nothing,
are
nothing,
what is all this?
nothing, absolutely silent.
Yeah. You set aside.
Lordship may be pleased to
What?
get the instructions, my lord.
This notice is vague.
No, no, notice is
If you
vague.
have anything, you are given liberty to take.
Yes, 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 yes. Notice is, my lord.
I'm okay.
No, no.
On the face of it. On the face of it,
I cannot defend it.
indefensible.
But the sad state is this was not contested, means I want something to the effect which would have been. That is why I said that this matter needs to be taken into account.
Well, no, because, my lord, here one has to, if I am serving a notice, being an authority under the law, my lord, the person to whom I am serving a notice, he should have the opportunity, my lord, to defend it without there being any schedule, my lord.
Now, what is Annexure 6?
Annexure 6, my lord, pertains to a proceeding, my lord, which was undertaken way back in the year 1981. That was pertaining to, my lord, a proposal for settlement of certain area of land. My lord, precisely acting under the provisions of section, it will be regulation 162,
So this is tribal land.
tribal land. Now, whether, but there, at page 33, if for a moment, my lord, kindly come to page 33. My lord, only an opinion was formed by the subdivisional officer.
Mm.
Indicate that the farm name as Mahabir Prasad Model Land comes under the purview of section so and so entitled to get settlement and so and so. Only this is an opinion. Whether this has been
No,
acted
no, no,
upon.
no. But then also this land is different.
Yes, this land is also again different. This
This
is, my
is
lord,
different. But you see, this document
my
does
lord.
not show what land.
Yes. No, no,
This notice is vague.
the notice is absolutely vague. That fact.
The instant writ petition has been filed. Challenging.
That is for the-
You are also asking for settlement.
Yes, otherwise the prayer is there, but we have relied upon this and expected.
Where is your representation for settlement?
That is not there in the repetition.
Not there.
He is always at liberty, my lord, to make.
That liberty.
There's nothing out there.
No.
The instant petition has been filed challenging the notice, eviction notice number JRC dot, J dot R dot C dot dash 14 oblique part dash 3 oblique 2019 dash 21 oblique dated 3/12/2021, as well as also for a direction upon the respondents to consider the case of the petitioner for settlement of the rest of the land measuring 2 kathas 5 lechas in favor of the petitioners at the earliest. From the records, it reveals records, and more particularly from the records, and more particularly from annexure 1 and 2 of the writ petition, it reveals that the petitioner, Sri Ajay Kumar Agarwala, bracket Bajaj, is the owner of a plot of land measuring 1 katha 3 lechas covered by DAG number 108 of KP Patra number 24, as well as a plot of land measuring 10 lechas covered by DAG number 107 of KP Patra number 144. Of Dhemaji, Jonai, lot number 1, Murkong Select number 1, within the district of under subdivision Jonai, and within the district of Dhemaji. It further appears that on 3/2/2021, the Circle Officer Jonai Revenue Circle had issued a notice to the petitioner stating inter alia that the petitioner was illegally occupying land of National Highway number 515, and the petitioner was directed to remove his house and shop from the illegally occupied land within 15 days. Being aggrieved, the petitioner is before this court challenging the said notice. A perusal of the said impugned notice dated 3/2/2021 is vague and does not contain any material particulars. In as much as there is no mention in what number, there is no mention as to the area of the land in occupation of the petitioner, in unauthorized occupation of the petitioner, as well as there is no reference to the boundaries on the number in the record of settlement or survey. In respect to which the petitioner has been alleged to be in unauthorized occupation. Taking into account that the said notice dated 3/2/2021 is vague and does not contain any material particulars, the said notice is set aside and quashed. Next, Mr. B. Gogoi, the learned counsel appearing on behalf of the petitioner, further submitted that there is a prayer made in the writ petition that the petitioner be considered for the petitioner be that the respondents be directed to consider the case of the petitioner for settlement of the rest of the land measuring 2 kathas 5 lechas in favor of the petitioner. From the records, however, there is nothing on record to show that the petitioner has submitted any representation before the concerned authority. Under such circumstances, it would not be proper on the part of this court to issue any direction upon the respondent authorities. However, the petitioner is granted the leave to apply before the concerned respondent authorities as per the extant laws and the policies and the land policy of the government of Assam. Before parting with the record, this court further finds it relevant to observe that the instant that the setting aside and quashing of the notice dated 3/2/2021 shall not preclude the respondent authorities to take appropriate steps as deemed proper in accordance with law.
I'm obliged.
Some personal difficulties.
Personal difficulties of whose?
CK Munir, my lord.
PK Muni's personal difficulty. What are you asking for?
Maybe adjourn for the day, my
Suspend. Hey, what is he asking for? Next. At the request of the petitioner, the matter stands adjourned to be listed again on 25th of September 2023. Interim order passed earlier shall continue till.
Much obliged.
Yes, Mr. Devi.
We pay for some time to file affidavit.
Who? You have not filed affidavit?
Lords,
What is the matter about?
matter regarding also removal from the register of companies. Petitioner name is removed from the register of companies. That was silence clause.
So why does this NCLT has no business nowadays? They closed down.
They can approach, yeah. But he is
They
like,
closed down.
still they will come to the, that point was already
Go first
in the
to
most
the
of
Hanuman
states,
Mandir
in the most
and
of-
on the back side you have the NCLT.
in the most
Eh?
of states, we have pointed out that point also. In the Moson state itself, also, that they I have pointed out that they have to approach the NCLT.
Then hello, we'll take it up on some other day. You want to file your affidavit?
If lordship
Now you
decide-
don't want. Huh? Because you see, these should be more effective
Lordship.
and they can very well do it out there. Should notice matter will do.
Lordship.
Anyway, list the matter again on 21st of August. So the liberty is given to the respondents to file their affidavit in that.
Lordship.
Deeply obliged.
की orders नहीं দিবলৈ কি আছে? Oh my. How can this be done?
Not-
This one? Authority to issue scheduled caste certificate and permanent residence certificate in favor of the petitioner. Is it
Lordship,
possible?
earlier the petitioners approached this honorable court and this honorable court has directed to, by complying the direction issued in Madurai Patil's case, to place it before the state level scrutiny committee. Thereafter, it was not placed. Because of that, he again approached, the petitioner has again approached. Most probably that was.
That is
done.
not
That
his
why-
prayer to place it. Anyways, none has appeared on behalf of the petitioner on call.
Most
List the
probably
matter
that-
again on 23rd of August 2023. It is made clear if the petitioner is not represented, the instant petition shall be dismissed for non-prosecution.
Most probably it was done, most probably. That is why, most probably it was done.
She can't help
Lordship,
it
Lordship.
today.
43.
Yes, complied. Yes, order complied. What is who is appearing for whom? No steps have been taken by the petitioner in terms with the order dated so and. What? It reveals from the office note that no steps have been taken by the petitioner in terms with the order dated 17/5. In terms with the order dated 18/1/2019. Taking into account the above, it seems that the petitioner is no longer interested in the matter. Under such circumstances, the instant contempt proceeding stands closed. Complied?
No, my lord.
Why?
Impleted new, for newly impleted, Mr. P, impleted incumbent, my lord, P. Gogoi appeared as per. our-
Then order is what? Not complied with.
My lord, the price escalate,
In here, the court directs the respondent to examine the petitioner's claim regarding non-payment of the price escalation of Iman as per the direction of this court in Tamser Singh within 2 months from the date of receipt of Tuen. Then what happened?
Nothing happened.
When did they appear first?
My lord, recently after newly impleted increment, my lord, P. Gogoi appeared for the response as per office note dated 4/8. My lord.
Taking into account that the respondent has been had newly engaged. Respondent number 2
2 years.
have recently appeared before this court. This court finds in the interest of justice grants 15 days time for the purpose of filing the affidavit. This court, however, expresses displeasure in the respondent number 2 not being represented by the counsels. List the matter again on 25th of August 2000.
My lord, here I appear for respondent number 3 and 10, my lord. There was a direction to obtain instruction, my lord, whether some of the amount, otherwise the major part has already been paid, my lord. Some fund has been, amount has been deducted. So to that effect, my lord, I was directed to obtain the instruction, my lord. I'm yet to receive, my lord.
That was given in the month of May.
My lord.
How much time does it take? From where?
From Dhemaji, my lord. I had the telephone instruction, my lord,
My
for the written instruction,
goodness.
my lord. Very short date, my lord, I'll
You
get
say
it.
Dhemaji as if it is in San Francisco.
No, no, I have
Then-
not at all. Some
When?
Next week, my lord.
Okay. Mr. G. Pegu appearing on behalf of the respondent contender seeks an accommodation to obtain the instructions in terms with the order dated 26/5/2023. List the matter again on 21st of August 2023.
My lord.
In this case, my new incumbent as the chief engineer of public health, engineering has joined us. So we are going to file implement petition soon.
The
Already,
learned counsel appearing on behalf of the petitioner seeks an accommodation for 6 weeks, taking into account that the chief engineer's post, that there is a new incumbent in the post of the chief engineer,
public health engineering department,
public handling,
48 of same.
48 same. 49? Yes, complied.
My lord, already the order of your lordship is complied.
Where is that? What is the direction given?
My lord, direction was given, my lord, lordship on 15/8/2019, my lord.
Demarcation process.
Yes, my
Done.
lord.
Complied.
Yes, my lord.
Yeah. The learned counsel appearing on behalf of
Contentment number 2, my lord.
contendant number 2
Yes, my.
submits that the demarcation proceedings have already been completed in terms with the order dated 5/8/2019, passed in WPC number 3483/2019. Taking into account the said statements so made by the learned counsel, the instant contempt proceeding stands dropped. Tick. Any interim order to be extended? Nothing? Okay.